According to the great atomic clock, I'm about to lose my lunch.
Oh, okay.
Okay.
I thought I was going to leave. Thank you, boss.
All right. Let's come to order. It's 4 o'clock. Hey, come on in.
Thank you very much.
It's 4 o'clock, and the chair
4
notes
o'clock somewhere.
that it is 4:01 Central Standard Time here in Walton County. And we're at the Annex, and this is February 13th meeting of the Customary Use Beaches Advisory Committee or Activities Committee. Let's first thing the phones. Let's put them on buzz or whatever to remember that. Again, I would request that you give your name whenever you can when you're saying something so we can record that correctly. And most of all, Debbie Wheeler called me and says she can't understand who we are unless we tell her. So I'm teasing with you. Now, in Louisiana, where I come from, we never plan a meeting without first planning food for it, and that was the most important thing. So on Valentine's Day, I've brought some goodies we can pass around and hopefully can endure the time that we're going to be here. I do note there is a quorum at this time, and I don't know whether we have gotten the minutes from the last meeting. Has everybody gotten minutes from the last meeting? That was the 6th. Is there a motion or any changes with regard to the minutes of the last meetings or corrections that anybody wishes to make? If not, I'll entertain a motion to accept them.
I move we accept the minutes.
Okay, there's a second. Okay, all
Second.
all in favor, please say aye.
Aye.
Okay, yeah.
Who made the motion to accept the minutes?
Beth
Oh,
Clay.
Okay, Beth,
I
thank
learned
you.
all that stuff.
No, that's all right. Don't worry about it. Okay, now, this evening, we're going to have, it's going to be a special evening because it's longer, but I talked with Larry Jones about bringing the sheriff in and inviting him in to explain what his job is in policing and the criminal activities on the beaches. And he's going to be here. Now, he's at a fire board meeting, and I had to skip my fire board meeting to be here because we want to get this concluded. But at any rate, the sheriff's at the fire board meeting, but as soon as he comes in, what I want to do is interrupt whatever we're doing. Let him talk and let y'all ask any questions of him that you may have, okay? So that will be something different. I hope that y'all have had a chance to read over the, I think, thoughtful questions that Rob presented to us so you can at least have those things in mind when we do some deliberations. And first thing, in this meeting, we're going to do it a little differently. We're going to take comments from the public first. And there've been some thought about doing that before, so we as a committee could understand what the public may have in mind. And we're going to offer the public some time. And then I'm going to entertain 2 different motions from the committee. I'll entertain a motion that would basically state that this ordinances that we have been studying should not go into effect on April the 1st. And incidentally, on each of these motions, no matter what your vote is, you're going to get 10 minutes to publicly speak to your reasons for voting one way or another. And it still won't preclude, if necessary, your right to write a 500-word reason out as well. The other motion that I will entertain will be a motion to the effect that the ordinance should go forward, but with certain recommendations. So, y'all can be thinking about those. Now, after we make the motions, and we do that, or before we make the motions, we do that, we're going to ask Rob to come in and, again, give us some food for thought about what we're about ready to do here. But in each case, in any case, each committee member today is going to get at least 10 minutes after a recess, after they have had time to sit down and think about how they want to respond to this. After a 30-minute recess, to sit down and respond, to give their reasons for however they voted. Okay?
I'm not sure I understand. So you're making those motions, or you're?
No, I'm not making them. I don't make it. I'm just saying I will entertain if someone wants to make
So what we discussed?
those motions.
Other potential motions, or what's the? You'll entertain any other motions, or?
Sure.
Okay.
I'll take anything that y'all have that pertains to the subject matter here. Okay?
Well, I would, if this is an okay time to do it, I'm not sure. A motion to move forward with the ordinance as passed would be an obvious
Well,
possibility.
this is not the time right now. We want to hear from public comments first, and then we're going to get into the question of the motions, okay?
And Judge, could we also try to wait and see, because as far as I know, Governor Huckabee was the only person not planning to be here tonight.
That's fine. The meeting was,
Yeah.
we'll wait as long as we can before we get into the motions, okay? But we have to move on. At this time, we will entertain comments from the audience at this time. Whoever wishes to speak again, we'll be giving you the 3 minutes. And if you want to, if you'll use the podium and do that, yeah.
Richard Bryan. All that are involved are beach users. And so I think that anything that you could do to make the language, the do's and don'ts and all of that, more neutral, instead of this side this and this side that, I think is a good idea. Where it's possible. I understand that there might be some things that you definitely would have to make the separation, but where you don't have to make it, if you could do it in a more neutral fashion, I think it would be, it would read a lot better. I know that some of you probably will not be in favor of this, but I think if you allowed a 10% ad valorem tax exempt to homeowners willing to share to eliminate as many adversarial issues as possible. I think that the sheriff's office must enforce violation of laws that would apply on or off of the property basically in the same way. I think that the deputy should come to the homeowner's home first and be able to observe what the homeowner observes and listen. Complaint of actual law violations is what the homeowner should be making that complaint on. I suggest that recorded digital surveillance be done by homeowners. Might suggest that in the ordinance so that that is available when law enforcement does come, or code enforcement for that matter. I think if you had more trained code enforcement officers to deal with and intervene in disputes, that that would be helpful. I would like to see you follow the chairman's suggestion and to find what is an agreement and to make a list of that and what is non-agreement. I think that would help. I think that the beach activities ordinance should be referenced in the ordinance. And littering on the beach, including dog and human waste, strictly enforced with steep fines.
Thank you, sir.
Thank you.
Okay, other comments from the audience? Okay, you can refer to your document, Bob, make sure everybody's got a copy.
Bob Brook, B-R-O-O-K-E. I'm not really going to speak to the document itself. It's I handed out for your interest, hopefully your interest. It's just my shot at answering 6 of the 7 questions that the facilitator posed at the last meeting, with the exception of the one regarding the Frisbee activities in the middle of a wedding ceremony. I didn't bother to address that one. Not to slight the value of the question, but it just didn't seem appropriate for me to answer that one. I want to endorse the proposed motion, or at least the suggested motion, for either postponing or, if it were my preference, doing away with the recommended customary use ordinance, postponing at least till we fully explore, we, the county, the citizens of the county, the officers of the county, explore in more depth and detail alternative measures whereby they might avoid the litigation that's already in place and the additional litigation that I feel is sure to follow. Secondly, I'd like to heartily endorse what Richard Bryan suggested. I think he had good ideas there, and I think the committee should take a close look at a number of those. Thank you for your time.
Thank you, Bob. Any other comments from the audience at this time? All right.
There's someone that asked me to share some things with the committee. Would this be a good time to do that? If she were here, I'm sure she'd do it herself. But
What is it? What is the committee's?
it's just a couple of suggestions that she had that she would do the same way as these. I'm sorry.
What is the committee's response to this request for?
Sounds like public comment.
To be heard by proxy, one of the committee members, please.
Yeah, I don't see any, Chuck Schneider, I don't see any problem with that at all.
Okay, anybody else?
Is it public comments?
Yeah,
Yeah, I think we should definitely.
She basically thanked us all for serving the time on the committee and stuff. And
Who is this?
her name is Kelly Anderson.
Okay.
Kelly Anderson comments. She basically there were 2 things she primarily addressed. One being the enforcement issue, which we're all very aware of. And, I think we all realize that there needs to be better enforcement, and we've got more staff to do that this year. So that one we don't need to go into a lot about. But she did suggest an idea about having a specific number that beachfront owners could call quote enforcement for violations, as opposed to just a number that everybody in the world's trying to call all the time. I don't know how feasible that is or not, but I thought it was worth a consideration. Her second comments were predominantly regarding tents. Her suggestion is that there be no tents, other than possibly having a tent permit for owners similar to like you would get for dogs or bonfires. I don't know how feasible, again, that would or would not be, but, you know, she's basically saying that if you have a legal right to the property because you're the owner or in a common interest community, for instance, like Rosemary Beach or Seaside or whatever, that those folks could have an annual permit to have tents by getting some kind of a permit or authorization. And so I just wanted to pass those on because she asked that, she said she might not be able to be here and she wanted them shared on her behalf. So thank you.
Okay. Just for your information too, I went to the awards ceremony of the South Walton Fire District here last Sunday. And I was surprised to learn that we issued over 3,000 bonfire permits last year. So it's not a small issue on the beach. It's significant. Anyway, that's just an aside. Rob, would you come in and give us your guidance, if you will, on thinking about what we're getting ready to think about?
Sure. I appreciate it, Mr. Chairman. The 7 questions that I asked, I'm sorry. The 7 questions that I asked at the end of the last meeting were designed, at least in part, to explore the boundaries of each position. And if, for example, in considering the first or the third question, should private property owners be able to put up a wooden fence, a chain link fence, a barbed wire fence? If your inclination is on the private property owner side and you concede that it is a proper, what is called in the law, police power of the county to restrict, for aesthetic reasons, for public reasons, et cetera, the type of fencing, if any, that one can put up on their property, whether it's on a beach, whether it's inland, then it seems to me that you naturally will accept that at some level private property rights are not absolute, that they do give way at times to matters of public. The question about having a wedding reception on your dry sand area is recorded in the deeds of Walton County, and whether you would have to give way in the middle of your daughter's wedding reception to tourists throwing frisbees in the punch bowl was also designed to take that to an extreme. And if you concede and your tendency is to be public access and public use, but you recognize that that would be too far and that would be inappropriate, then hopefully from that you see that some respect of the private property is due. So if you don't agree with either of those, and you think that those rights exist in the absolute world, you're certainly entitled to your opinion, but I don't know that you're going to be able to come off of any position like that. So those are the questions I wanted you to think about, and those were the reasons why. I mentioned to the judge before we began, normally at this point in a process where, I won't say battle lines are drawn, but where people have very, very strong feelings one way or the other, if this is in litigation and it is in mediation, at this point it's not at all uncommon for the mediator to come to each side and say, okay, we seem that we're pretty close to not reaching any agreement at all. Let me give you your worst case scenario. And so I wanted to take a few minutes before you get down to the nitty-gritty work that the judge mentioned and give you, based on my feedback from you all and interpretation of the events, what I see as the worst case scenarios and the weaknesses in each position. For the public use proponents, you may lose in court. The TONA Roma decision from the Florida Supreme Court was 43 years ago. It was a 4-3 decision. The court membership clearly has changed, and it may have changed philosophically. Or it could be that you go back up, and Tona Roma is interpreted to uphold the customary use doctrine, but on a parcel-by-parcel basis, in which case you look at having a checkerboard of customary use potentially on beachfront property, not just in Florida, but around the state. And you could lose that. The ordinance, the customary use ordinance, or even the very doctrine of customary use itself could be deemed unconstitutional. It could be deemed a taking under the Federal Takings Clause, which you're probably all aware says the government cannot take private property without paying just compensation. And the doctrine itself could fall to that federal constitutional provision. And were that to happen, you very well could see fences of some sort going down to the mean high water line. For the public, or for the property rights proponents, I would offer this. You may lose in court. The Supreme Court has already decided the issue that you're considering. And they decided it 43 years ago, and it hasn't been changed. In the law, that would mean that you have a very heavy burden to try to get an appellate court to undo a decision or to recede from a decision. It happens, but it's a very heavy burden, and you could lose that. A federal court may very well find that the use is not a taking and may adopt the language that the Florida Supreme Court used in Tona about the unique nature of beaches and how beaches are different from other land because you can't farm on them. You can't pave them. You can't do all the things we do with inland property on the beaches. Beaches you can enjoy. And a federal court may agree with that and may adopt the customary use doctrine and conclude that that this is not a taking. And now you have gone all the way through the system and you have lost, and you have very limited say-so on what happens across that property that you're still paying taxes on. And, on the other hand, consider Walton County is one of 67 Florida counties. At some point, does the state of Florida get involved in this discussion? Is the state of Florida going to allow its beaches to be privatized, at least down to the mean high water line? Is the state of Florida going to allow that? And what would happen to tourism in the state if it allowed that? And we all know that one of the reasons we enjoy a state income tax-free lifestyle in Florida is because of the value of tourism. If beaches are allowed to be restricted and tourism drops down, at some point, are we looking at the introduction of a state income tax to offset the lost revenue? Or alternatively, if we're not looking at that, are we looking at the legislature having to float 20, 30, 40-year bonds to finance the acquisition, the takings, if it goes that way, of the dry sand areas? And if so, how do we pay that, and what services end up falling? Because now we're deep in debt and we're paying that. So it seems to me that one way or another, there are substantial risks to both sides. For those depending on the U.S. Supreme Court making a test case out of this, you simply must admit the simple fact that 98% of cases that seek review in the U.S. Supreme Court are denied, just rejected. out of hand. It's no guarantee that just because we might feel strongly about something that the U.S. Supreme Court is going to hear it. In which case you're going to be stuck with whatever, if it's in federal court and it goes up to the 11th Circuit in Atlanta, whatever the 11th Circuit says. So I did hear the suggestion about a property tax discount or a property tax abatement. My understanding is that would be unconstitutional under the Florida Constitution based on the constitutional requirement that property be appraised fairly and uniformly. And I don't think the county has the ability to abate a property tax or to let some people pay less than other people in the same county. So those are the boundaries. Those are the boundaries as I see them. I think you all are in a unique position now. You know more about this issue, probably than nearly everybody in the state. And you're in a unique position to now see if your minds, having heard what you've heard, listen to each other, having a resolution to vote on, if you have some way to solve this problem without taking the risks that litigation has for both sides. So with that, Judge.
Okay. All right, folks, what we're going to do now, first thing, let me explain, the chair does not vote unless it is to break a tie or create a tie. And that's just from Robert's Rules of Order, that's parliamentary procedure, okay? So what I'm going to ask, is there anyone that wishes to make a motion to the effect?
Question first, Judge. If Tammy's on her way, she's the only person on the committee from the north end, I believe. Have we heard from her? Question was, Brenda Reese, whether anyone had heard from Tammy, whether
From
she's
who?
not coming?
I haven't.
That Tammy called and is not going to make it today?
I haven't heard. I haven't heard, nobody's contacted me at least in any event. Okay.
Yeah, I'd like to make a motion that the panel engages in some more discussion, given that the suggestion that's been brought by our chair hadn't been discussed before we came in. Does anybody want to talk about
Is there a second to that?
about the pros and cons of getting into a vote tonight?
Is there a second to there's a second to the motion. All in favor of further discussion before we enter into a vote on a resolution? All in favor of?
That motion hasn't been made yet, whether we're voting. Just want to clarify.
I'm voting on your motion. Okay, voting on your motion.
Sometimes don't
Okay.
understand.
All in favor of his motion.
Can you repeat your motion? I got to get confused.
I'd move to use some of our time for discussion amongst the panelists about the pros and cons of entertaining the chair's potential motion.
Some further discussion, and there was a second to that.
Got it now.
All in favor of that motion?
Mr. Chairman, I ask one more question. I'm
Go
sorry,
ahead.
I
That's
entered the
okay.
meeting a few minutes late, and I don't think I heard I think it's a potential
It wasn't a
motion.
question,
All
it wasn't a
right,
motion.
Let me back up then. For those of you who came late, I am going to ask the committee to come up with two motions, or see if they want to come up with two motions. One would be that the customary use ordinance not go into effect on April the 1st. The second motion that I would entertain would be that it would go into effect on April the 1st, but with recommendations from this committee. Okay?
Yes, sir.
All right, so now let's get back to his motion. There's been a motion and a second to continue the discussion of this issue before we do any voting. We're going to, incidentally, after you vote, we're going to recess for 30 minutes at least. We're going to let each member of this committee collect their ideas, their individual ideas. They put them in writing, do whatever you want to, and then when we come back on each of the motions, we're going to let you have 10, or maybe we only have a few of us now, 15 minutes to put on the record your reasons for your vote, one way or another. So,
So my motion is still on.
yeah, your motion is still on the floor. All in favor? Aye?
Aye.
Okay. Open it up.
Okay, yeah, well, to start, I just think that
Shall there be any cutoff time for this?
whatever we've been using before,
Okay. Well, no.
10
go
minutes,
ahead.
3 minutes, something like
Well,
that?
right now, it's just open. It's open discussion.
I would,
Oh, you mean for the
Somebody
whole
can-
discussion?
Somebody can move to cut it off later on.
What if we
okay?
talk for 20 minutes?
yeah,
No, that's
Does that sound all right?
at your leisure.
Okay.
I think you should just.
Okay. Yeah, it just, this part I have concern with because, well, first of all, it wasn't generated by our panel. It might be a good idea, but it wasn't generated by our panel to have a vote on either of those two things. And there could be any number of other motions that we might consider. I think also if we were going to have some sort of a vote on that or other language, it's probably better to hear from each of us before we do that than after. If we were going to do that, right, because we're trying to talk with each other about our positions, it doesn't make sense to me. I mean, it makes sense as far as getting in the record, but as far as working with each other, it may not. So maybe if y'all like the idea of the voting on some language, which I'm not sure I do personally, but maybe you do, that maybe we consider the order of those things where we share with each other ideas before we do something like that. So that's my couple of thoughts going forward. Anybody else have other thoughts on that?
I don't know, but I just saw the sheriff out there.
Oh, is the sheriff there? Okay, sheriff?
Well, I saw him walk that way, so I mean, and you had said we were gonna stop when he's not here,
As soon
so I
as the
just,
sheriff comes in, we want to conserve his time as much as we can. And he comes in, we'll just recess
Okay.
what we're doing here and listen to him, or interrupt what we're doing, not recess, but interrupt what we're doing. Incidentally, we have some food here.
I need
Pass it
some.
around.
This is not mine.
Oh, no.
I thought you were planning a long meeting.
No, I was telling everybody that in Louisiana, you don't plan a meeting without first planning the food. But at any rate today, so if y'all take what you want and then pass it around, okay?
but I agree with what you said about, before we vote, we ought to discuss, what our thoughts and ideas are, because maybe someone will go, oh, well, gee, I'd never thought of it that way, but, I think that's a good idea. And
Okay,
I'm just going to throw right now that last week.
but let's just do it in turn then. Do y'all
Okay.
want to do that? Have your discussion beforehand, before you vote?
I think we haven't established that we're voting yet, so that's it.
Oh, we're going to vote.
And I was,
Okay, we're going.
Brenda, and I'd like to maybe do the question. I thought that discussion might be interesting. The questions that were posed to us last week, rather than helpful somewhat, perhaps, dialogue.
Okay,
But if we are going to do the discussion on the motions and then vote on them, I think we definitely need to start thinking about our time, and here comes the sheriff, okay, so.
They did show up.
Sheriff, welcome.
Well, I don't know how welcoming this is gonna be now. How are y'all this afternoon?
Good.
Doing good.
Come right in. We appreciate you being here. And at the last meeting, there was some discussion about law enforcement on private parts of the beach, private ownerships and non-private ownerships, and how you treated that. And also, there was questions about trespass and how you were treating that. But, if you could enlighten the committee and the public, we would appreciate it.
Another question is how customary use could help your agency to perform its duties.
That's multiple questions. Let me give you a kind of an overview of where, if this is okay with you.
Sure, absolutely.
Okay, great. So let me try and give you an overview of what the status is and what the potential implications. And a lot of that is really determined by what steps the board takes and what the final decision is made about what the definition of customary use, if that's enacted, how that would work. There's a lot of factors to that. So let me just kind of give you an overview of how, because I was on the phone with the state's attorney's office today. This thing is driving me nuts, Rick, so we're either going to have to do something else when I'm on this.
That's okay.
That's going off my whole thing there, I'm just going to tell you. So,
That's okay, we can hear you, we can hear you.
yeah, I think I'm pretty loud, so I think you'll be able to get that. What you have now is a series of things that have changed over the last few years involving private partnership property, as you guys all well know. A few years ago, one of the issues that we started hearing with the owners, beachfront owners, was simply this: I am okay with somebody using this property, X, Y, or Z. It's fine by me, X, Y, or Z. The problem from a purely legal standpoint, as you may well know, either you have the authority or you do not. And so while of multiple beachfront owners, if all of you are owners and one of you says, I will allow this, and the next one says I won't, and the next one says I will, and the next one says I won't, you get into a situation where we're trying to determine a couple of things. One, who has standing, right? In other words, who is capable of setting the established rules for that piece of property. You have that issue. And then you have the other issue, again, which is kind of a blanket issue. You either have the authority or you do not when it comes down to it. So from the standpoint of the sheriff's office, one of the biggest things that we've always struggled with was who actually owns the property. Where are the property lines? And so anytime we dealt with an issue of trespassing or perceived trespassing, and by the way, this is not a personal opinion because quite frankly, how I feel about it personally is completely irrelevant. It simply matters what the law is in this regard. So if it was a public property rights issue, notwithstanding customary use, then you have the legal right to remove somebody, period. No difference North Walton, South Walton, whatever the situation may be, absent customary use. So if we went down to a piece of property, again, the first thing we would try and say is not so much the north-south line. People would get caught up over whether it was 20 feet from the water, wet sand, a lot of different rulings. The real issue for us largely got into east-west boundaries. Where are the edge of your property? And so if it is a complete private property, just like it would be on a farm somewhere else, then yes, somebody would be able to block you going across the beach. Absent customary use, if it's private property, my understanding of the law would be that they could prohibit somebody from crossing that property. Okay, so you have that issue. For us, it really boiled down to determining, A, whether or not that right existed with the property owner already, which that's not the sheriff's purview to say that. B, again, whether or not they were the actual owner of the property. Were they on the property that's in question? That got to be a huge issue over the last probably 10 plus years. But technology changed, which is GPS primarily. And so with the GPS global positioning systems, it allowed really accurate findings of where property lines were at. I mean, within plus or minus a couple of feet. So a few years ago, there was a DEP survey, which is kind of this really super heavy-duty survey that was done that some of the property owners haven't done. And we had some property owners that came forward and said, hey, listen, I've got this survey. I can now clearly delineate by GPS where my property line is at, and I don't want anybody to cross my property. The problem is, a problem for me, as a purely legal standpoint, I don't have any say in that. If that's what they're saying, and that's the law, absent me being told by a separate body, I don't get to say whether or not it's private property, but not this kind of private property. That's a decision that the board, the legislative bodies have to make as far as whether or not that property has always been open to the public, customary use, if you will. So that's kind of where that's kind of where it was at, absent customary use, which is people starting to get the GPS type survey that allowed for very specific delineation of property lines. Now, again, a lot of property owners would say to us, hey, Sheriff, we really don't care as long as they're just walking across, so be it, that's fine. But the issue is you may be okay with that, but you don't have to be. Somebody else didn't have to be. They could then choose to prevent somebody from crossing that piece of property because it's trespassing. Customary use, let's talk about that for a second. If customary use is enacted, and that is the issue of whether or not, or how it would be enforced by the sheriff's office, code enforcement, whoever the situation may be. as I understand it, I had a kind of a lengthy conversation with the state's attorney today, and I've done this on a couple of different times. From a criminal standpoint, and that's what we're talking about now, strictly a criminal standpoint. If you pass an order, depending on what the ordinance says from a customary use, and I'm going to use hypotheticals because that's probably the best way for me to work forward. If you say customary use is in place, and these are the things that the public is allowed to do south of the toe of the dune. I'm going to use that arbitrarily and capriciously. I'm not advocating one. I'm just trying to give you an example. If you say it's okay for the public to pass, not in the wet sand, which there is no discussion about the wet sand, that's been decided many moons ago. But if you say that the public is able to walk across south of the toe of the dune, but not in the wet sand, okay? That is a customary use there. If you say the public is able to sit there, okay, so be it. But let's just say you say the public cannot deprive the property owner of the use of their property. Let's say set up a tent. That's probably one of the biggest ones. That we say customary use is not setting up a tent, setting up sound systems, things of that nature. So what the sheriff's office or code enforcement, whoever the entity may be, would come along and say, sir, ma'am, whatever, you cannot set up a tent here. And what they're going to say is customary use, these beaches are open to the public. And we're going to say, no, well, that's not how that works. How this works is customary use does not, it allows for sitting, and I'm just, again, using a framework. It allows sitting, standing, walking, fishing, swimming, whatever. Doesn't entitle you to set up and have beach blanket party here. So you're going to have to take the tent down. The difference is, in the past, let's just say, Judge McGee, it would have been you was the property owner. You would have been the complainant. In other words, I need to write your name down as the property owner. I need to prove that you own the property, that you have standing for this complaint. The difference, as I understand the customary use ordinance, is instead of the individual property owner being the complainant, the county is then the complainant. It's a violation of a county ordinance. So now, instead of having to say, who actually owns this property? Let me get some GPS. Let me get out here and mark this. Do you have the clear title? Has it been stamped? We would simply say, regardless, we know that customary use in Walton County does not allow tents if you're not the property owner or permission of the property owner. Hereby, this citation is issued by the county, if that makes any sense from you. Instead of trying to go to you, yes, ma'am.
Well, so if I'm down on the beach, I'm not a beachfront property owner, but I'm just down there and I don't have a tent, but I see some people coming, because I've seen they're setting up 3 tents and like the whole party. I can, well, if they're sitting down on Lisa's property, I can call and say, look, there's some people down here, and they're not supposed to be doing this. So anybody can file that complaint.
I mean, and I'm, again, that would be my short thought about that. Is yes, you can't have a tent down on there. Now, what they may say is the property owner gave me permission. Now, if that's the case, then it's the property owner's property. They can make that decision. So, but yes, the short answer is my thought process would be that anybody could lodge that complaint. That takes some review, but that would be kind of my first blush would be that, yes.
But the sheriff could initiate that when they see the violation.
They could, but so I guess there's two philosophies about that. Do you really want to go out and have us start walking around to people and go, you got a tent? Are you the property owner? You need to be putting here.
We've been discussing.
Yes. But these are the kind of things, or your code enforcement, whatever the situation may be. Yeah. If the property owner, if somebody calls, and I actually think it should be probably driven by complaint. That if you're just asking off the top of my head, I think it probably should be driven by complaint. Doesn't matter who the complainant is. You can just somebody call and say, hey, there's a tent on this piece of property, X, Y, or Z. And unless they're the property owner, or have standing in it, or have been given permission by the property owner, I would think that would be predicate to have it removed. So, yes, ma'am.
So if there was a system by which property owners were to give authorization, would it be better for you if it was done similarly to bonfires, that sort of thing? Then
I don't think you want to get. Short answer is no, okay. Because you would be getting into some really massive paperwork tracking for something that's somewhat de minimis. Here's what I would say: if I make contact with Bob Jones, and Bob doesn't live there, and he says, I know Bill Fletcher, and Bill Fletcher's property owner, he just says it's okay with it. If Bill Fletcher hadn't called and said anything else about it, and he's not worried about it, then I don't think we should be saying anything about it. That's kind of my short. If you can tell me who the property owner is and when they gave you permission off the top of your head, could somebody get over on us? They could, but we're not talking about the Lindbergh baby either. So at the end of the day, if they can say who the property owner is And when they were given permission, and it's not on somebody else, then I think you're probably okay from that standpoint. By the way, that would be no different as it's done now. I mean, from the standpoint of the property owner, if it was something that was maybe, for instance, the sheriff's office doesn't do leave no trace. We don't participate in that for a couple different reasons that I won't get into at length here, but not the least of which has to do with whether a private property issue. And we kind of say if it's right up there by the property owner and it's their property, then we're not gonna address it from that standpoint. So similarly, I would see it working like that. Yes, ma'am.
Is this a legal matter, or could code enforcement do that?
Oh, I think
Because,
strictly.
for instance, there are many of us that do not allow vending on our properties.
Absolutely.
And so what code enforcement has at this time is a GPS system. Sorry about that. Oh, by the way, Lisa Bauschy, we're supposed to tell who we are before we speak. Code enforcement has a GPS system where they actually know that, this section of beach, all the beachfront owners have said no vending.
Mm-hmm.
And do you all have any such thing, or would that be something better done by code enforcement in that case?
I think it's basically a code issue unless you get somebody refusing to leave.
Okay.
The issue for us becomes when you have non-compliance.
So code enforcement
Very
could
similar to
then call
parking.
you.
Yeah. If
Yeah.
somebody said, no, I'm not going. I'm
Yeah.
not going. Or obviously if the complaint came to us, we would, go and deal with the complaint. But by and large, we want to see who is the complainant, what's the issue is. And most times you're going to get compliance. The only time we haven't gotten compliance, the only arrest to my knowledge, even on the trespassing issue, in the last few years had to be when somebody specifically said they want to make a case, that they wanted this issue to go to court. And so those are the kind of things. I mean, typically we're going to get compliance. Code enforcement officers are going to get compliance. I think the county took a pretty strong step by hiring the additional code enforcement staff. I think that is going to be, a significant impact and help to the tourist visitors and property owners from that standpoint. So we'll see how that moves forward. So what else, guys?
Other questions? Sheriff, guys?
In the public?
What level of enforcement does code enforcement do? I mean, what exactly do they do? Do they issue citations or?
Sure. It's just like glass bottles on the beach, plastic bottles. Those are the same kind of things sheriff's offices do. But here's what concerns me a little bit when you get a deputy sheriff doing things. There is the color of authority of law. If we get into regulatory things, I'm always a little concerned when I see law enforcement officers because there is a different understanding of what your level of compliance is, right? To put it another way, never demand what you can't take by force. Right, if that puts it easy. And people assume when a deputy sheriff is there talking to them about X, Y, or Z, that they have the authority or the standing to be doing whatever action it is they're taking. It doesn't mean that we can't issue the parking tickets or the glass bottles on the beach, which we do, those kind of things. I just would be careful not to criminalize every type of behavior. I mean, I think fines get you where you need to go on a lot of this stuff. I think you're going to get compliance. I really do. There's a serious misunderstanding from what I understand that customers use and what some people think they are getting, which is it's going to be different. I think that is going to be a serious education, if customary use is passed, because I think there is a misunderstanding that if it's customary use is enacted, that the private property owner gives up all their property rights, and that's not accurate from my understanding of it. So you're still, if you are a private property owner, and I don't know whether you are or aren't, you are still entitled to the reasonable expectation of privacy and use of your property. And if somebody's depriving you of that, I think you're getting that issue. So if you remember, there was a case probably 6-8 months ago where there was an argument between people on the beach. And one of the biggest issues that what people didn't understand was not whether or not the owner had the authority. It was the way he acted that was the issue, if that makes sense. Mm-hmm. So, it was the actions he took. There was another incident, some of you might have saw in the news last year, where someone slapped the cell phone out of somebody else's hand. It wasn't that they did not have the authority to have the person removing the property. And it was interesting because so much of the public called us and said, you can't do this. That's crazy. It's public beaches, and we're going to have people removed. That wasn't the issue at the time. The issue was how it was handled. And so that's what this body will advise to the board where you want to go from a standpoint of customary use or not customary or whatever's decided from that. But I think a lot of it can be handled with the deputies and the code. I mean, I think you're going to get compliance once we start on an education campaign, if that's what you decide. Once you define clearly what you want customary use, what is and is not acceptable yet behavior, if that's the path that's taken, that is what's going to be crucial, that you set the parameters of what is and is not acceptable. And I hate to say this, and I know you'll find this hard to believe, but there are unreasonable people in this world. And that's shocking to you in this venue. But I will tell you, we've literally had people say, no, I want to move 2 feet. I want to move 2 feet. You know, and that's where so somebody, the deputy or the code, has to be the arbiter of reasonableness at some level. And that's what we're going to try, and whatever you do, to be reasonable. Yes, ma'am.
Do you feel that once April 1st comes around, and if this is going to be put into place, that your office is going to be flooded with calls?
For a while, yes. I mean, because again, I think you're asking me something that's getting outside of my purview a little bit. So this will be a decision that the board will have to make, or the TDC. What I would suggest is, once you decide whatever capacity, customary use, or whatever's decided, that you go on a heavy educational component. Heavy education, that people understand, because just in my dealings with the public, they simply do not understand what they think they're getting, and or what the property owners think they're giving up. And I think that is the real crux of what I see is going to happen. Is we're going to have a lot of times deputy going there, I'm sorry, no, that doesn't mean you can hold a protest on somebody. I mean, just to be frank with you, that doesn't mean you can sit up outside of somebody's house and turn your speakers all the way up and have a beach blanket party and hold a protest. That's not what we're talking about, because that's something entirely different. That'll be the key, I think, for probably this season after that. I mean, we just have to be prepared to answer questions and deal with it. But I do think an education component is going to be really, really key from this standpoint. And a lot of that is predicated, and I don't know the exact charge of this board or this committee, but I think whatever you define, and if that's what's accepted by the board, we'll adjust our practices and policies based on what the board tells us from that standpoint. I mean, and again, I get asked this all the time, what my opinion is. It doesn't matter what my opinion is. It is completely irrelevant.
Do you see that we need to make sure that this ordinance, assuming we go ahead and make suggestions, that the ordinance be very specific about what is and is not allowed?
Sure, specificity is always, I mean, I don't care what you're doing, it's much better. And I think you can't policy write everything, but to the best of your ability, it needs to be clear and direct guidance on how you want these things handled. I would, again, caution you to try and make everything a criminal violation. I don't think that's necessarily appropriate.
No.
But you just need to lay it out. This is the boundaries, this is the procedure. Something that will not require, I'm telling you, when you're walking around with GPS monitors trying to determine where things are at, it gets difficult. It gets very, very difficult, from that standpoint.
One question it seems like we got into before, the difference between, we're looking at customary use, whether or not, people can actually use the beach. And then there's also this beach ordinance.
The activities ordinance.
The activity ordinance, it's my understanding, and I did briefly read it, it is long, defines what can be done on the beach, whether it's on a private owner or public. So if you adopt customary usage, we just basically open the beach, but the actual enforcement's going to be done through the beach activities. Is that a fair statement?
That is not the way I would foresee it. Now, again, I haven't gone through the beach ordinances from that standpoint. I'm not even super familiar with what that is from a standpoint. Now, just can you give me a little direction on what you're specifically talking about so that I know?
Well, whether they can put up a 10 by 10 tent on your property, whether it's public or private, whether they can have boom boxes or set up parties and have booze on the beach.
That's what the ordinance says?
That's what
Beach activities.
That's what the beach activity ordinance states.
Well,
on private property?
It's
by the owner?
It would be across everything, whether it be private property or public property.
Sydney?
Please, let's do Sydney.
Little help here before we start.
Yeah.
Yeah.
So I'm not sure if this is on.
Unmute the arrow at the bottom, just flip that switch.
Can you hear me? Okay. So I guess this has come up at a lot of our meetings what's in the beach activities ordinance versus what's in the customary use ordinance. So the beach activities ordinance governs a lot of different activities on the beach, both public and private, but there are different rules for public beaches versus private beaches, and some are uniform across the board. And there is a lot of activity that a lot of the beachfront property owners are concerned about. That activity is prohibited by some of the provisions of the beach activities ordinance, such as amplified music, vending on private property without the private property owner's permission, things like that, glass and litter on the beach. But the customary use ordinance, and this has come up a lot, you guys have had concern about how do we regulate activity under the customary use ordinance, but I would say that as it's written right now, there's activity that's prohibited and there's activities that's allowed. So I think it's perfectly acceptable for you guys to expand that list of allowed activity and prohibited activity, and a violation of the customary use ordinance is a civil citation. So if somebody went beyond what was allowed or underwent some of the prohibited activity, they could be issued a citation by code enforcement.
Does one ordinance take precedent over the other?
No, well, there's no conflict between the two. And I will do everything in my power to make sure there would never be a conflict between the two. So as long as there's no conflict, they work kind of in concert.
Okay.
So you could be issued a citation under the beach activities ordinance for littering or glass on the beach or dogs on the beach or anything like that. And at the same time, you could also be doing some sort of activity that would violate the customary use ordinance and be issued a citation for that as well.
And that's what's defined in the ordinance itself?
Yes,
Okay.
yes, sir. Yes.
So I talked to you a little beforehand, but so what theoretically could be done is if, let's say that this committee said no tents, period, even though the beach activities ordinance says tents can be 6 by 6 by 6, this ordinance could prevail on private property, so to speak?
Yes.
Or would you turn around then and try to make the two ordinances match?
As it stands right now, that wouldn't be a conflict.
That wouldn't be a conflict.
Right. So the board just recently adopted changes to the beach activities ordinances, and 6 by 6 by 6 tents are prohibited on neighborhood and regional beach accesses. And then the prohibition on tents by members of the public is already in the customary use ordinance. So there's no conflict
On
there.
private property.
On
Private property, yeah.
By members of the public.
So
Yes.
let me just, and again, because I haven't read the beach activities ordinance, you have to understand, and I don't want to comment on something I'm not super familiar with last time. From a strictly sheriff's office standpoint, if there's not a safety issue, we're very careful when we get to dealing with what may or may be private property on county ordinances. So, that's something we just have to kind of, we would have to look at. For instance, there's things, and again, that's a legislative body, the Board of County Commissioners' decision to make. But for things like glass and these things that are already out there, let's talk about amplified music for just a second. That's probably an easy one. Well, that was probably a bad choice. It won't be easier since we get through talking about it. The truth is that disturbing someone? That's really what it boils down to. I mean, listen, the law says amplified music, if you start hearing what is a breach of peace. If nobody's on the beach and nobody's around and nobody's complaining, I'm not sure that I see where we would be involved in that. You got bottles on the beach where it presents a danger to somebody else, or your music's loud enough where it's disturbing someone else. Listen, we would already be dealing with that now. I mean, so from my standpoint, I don't see that really changing a whole lot. The beach activities, that's the purview of the board for the way they want to do that. But I think the biggest issue, what you'll see is a lack of, I don't think you'll see the trespassing arrest, to be honest with you, more. Because now what you have is if they're south, and I'm assuming you're going to say that north of the toe of the dune is clearly you don't even have any customary use, you can't walk through there. Which is when I hear from a lot of private property owners, that's actually one of their biggest concerns is somebody walking by their house, up around by their home, and some of those issues. They have no right to do that now. They have no right, and so we can certainly address that. I don't see that changing. I mean, the big issue, that would probably be the last place you see the trespassing cases. I think the remainder of them are going to be on the beach, ordinance violations of somebody saying, whatever, a code enforcement officer comes up to person X who's maybe drinking heavily, let's just use that for example, and they get into an argument with the private property owner. At that point, from my standpoint, you're asking me today, you're depriving the property owner of the peaceful use of the property. You cannot go sit up on somebody, cuss them out on their property, block it. So from that, we would tell them to remove them from there. That would be my kind of take on that, unless somebody saw it differently, and I'm sure we'll get to that at some point.
Mike, for example, you could have someone sitting just off of private property with a loud boom box.
Sure, no different.
And that could be disturbing the peace.
Absolutely, absolutely. And in fact, quite honestly, that's the way it generally is.
Yeah.
They're not generally going to be on your property. They're generally going to be somewhere down. So if your conduct, your freedom stops at the point of impinging on somebody else's.
Or
That's
doing,
kind of
ridiculous lewd things or whatever, stuff like that.
yeah. There's nothing about this. Yes, ma'am.
What about cigar smoking on private property?
So here's what I would, and again, each case would be a little bit different. But let's just say that you're sitting on your private property and they fire up a bunch of cigars in there, and it's disturbing your property, and you're already there. My take would be tell them to put it out. Now, if you're just asking off the top of my head, I'd think about it a little bit. But let me tell you what I don't think that you could do. I mean, a lot of it. So if you go down and go sit directly next to them, just for the purpose they've been there an hour, just to show that you can have them removed, I think that would probably be a little more questionable from that standpoint. But I think generally speaking, we would go over and say, hey, listen, you need to put that out. Yeah, for sure. Some
Sure.
kind of reasonable expectation.
So I just want to clarify, if there are violations of the beach activities ordinance or even the customary use ordinance that, again, whether we live on the beach or not, should we call the sheriff or should we call code enforcement?
I think it's going to be a partnership. I think it's all of them, and particularly this year. I mean, I think it's going to be us down there and the code enforcement. I think it's a group effort. I think where you're going to see us largely involved, though, is where people are non-compliant, where they just refuse to do that. Strictly from a volume standpoint, that's where we'll be dealing with. The biggest crowds are in the public areas to start with, unless we're called down there. So in other words, we're not necessarily going to roll up and down the beach looking for violations of the customary use ordinance. That's not a good use of manpower, and quite frankly, we don't have that kind of manpower. So if you called us, or code enforcement calls us, there's an issue, then we'll go down there and address it from that standpoint. But that would be kind of my thought process on that. I mean, there's only a handful of beach patrol deputies at any one time for 26 miles, so we wouldn't roll up and down the beach looking for, from our standpoint, for customary use violations. But if anybody called, we would certainly go to them. So I see it being a partnership, quite honestly.
Okay. I see y'all down there. Somebody's down there all the time. There's always a truck going up and down, I have to say. So.
Well, we try. I mean, the reality is we try.
Yeah, and I've stopped the guy and asked him questions and everything, but that might have been code enforcement.
Well, you have to remember, if you don't, for a lot of people, the reality is if you don't see it, it didn't happen. So, the guy that walks in his house and says, calls Mr. Sheriff, I never see a deputy, no deputies ever in my neighborhood. Well, if he came by when you're in the house, and if you didn't see when you were coming in or out of your house, then it didn't really happen. We get into some of that too. Versus if you happen to see them the same pattern of time every day, it's not a bad thing, but it's just something to remember. Just purely pragmatically, you got 26 miles and no more than, on the beach, you probably have no more than 4 deputies, 5 deputies at any one time, unless we're dealing with massive spring break crowds. So, what else? I'm sorry, yes, ma'am.
That's a good question. Spring break.
Okay.
Now that it just goes into effect and the public knows that their beaches are there, what about spring break with kids and all that they do?
Listen, the bottom line is behavior that is not acceptable behavior is not going to be any more acceptable because of customary use. I mean, that's really the short answer. We'll still be, in some ways, it's probably a little bit easier to enforce because I don't have to track you down as an owner and I don't have to have you provide a deed and your GPS standing there because we know if this behavior is egregious or if it's outside of customary use, it's going to be outside for the entire 26 miles, for instance. So that's kind of one way we would probably try and approach it, if that makes sense to you. So if somebody is set up on your property, and we'll use this for example, and they brought out 4 or 5 coolers, they're stacking them up, and we just go there and tell you, listen, this is not acceptable. Doesn't really matter because it's customary use. It doesn't have to be you. And so instead of putting your name down as the party, we'll just say it's the county. Very similar to most breach of peace ordinances.
Sheriff, is it fair to say that criminal behavior is criminal behavior no matter whether it's on private property or on the other beaches?
That would be 100% accurate, Judge. And from that standpoint, there will be no issue from an enforcement from that.
Is there a way that, I keep thinking about your cigar and the Texan that threatened and the whole bit. Is there a way that the private owner of beachfront property can have priority for their usage under a customary use?
Well, I think that's, I mean, the way, my understanding, that's the way you would be doing it, is as far as, in other words, so, let me clarify. So if you're saying, if somebody is depriving you, as I understand what you're talking about, if somebody is depriving you the use and enjoyment of your property, your rights have a priority over the customer use side of it. Is that what you're asking me? Or are you talking about for calls for service?
Yeah, basically, yes. But I wouldn't want the private owner to be able to just say, yeah, you know, I'm being offended because they...
Throw them off. No. I mean, in there lies the devil's in the details, right?
Yeah.
Very similar to, I'm going to use loud music because I think it's probably the most analogous to this. At 9 o'clock on a Saturday, somebody called and said, I can hear the lawnmower in my house. County ordinance is back in your house. It's disturbing me. It's right on the walls. Well, you know what? That's reasonable. Mowing your grass at 9 o'clock on Saturday is reasonable. Guess what? Mowing your grass at 3 o'clock on a Wednesday morning on school night is not reasonable. Same activity, different time, different application. I see that being what we're going to be dealing with a lot down here. What is reasonable? What's not reasonable? And we'll get it wrong sometime. We'll get it right sometime. But if you walk, and again, I'm going to use a cigar for a second because I actually think that's a pretty decent one. If you're already on the beach and you're sitting down, or you see them down there and you decide to go sit right next to them so that you can be offended, that's not reasonable. I'm not saying that you would, but I'm just using that as an example. There are people that do that. So just so we're clear, that there are people that you know that are not reasonable from that standpoint. But the flip side of that is, you're there with your family, your children, whatever, you're enjoying your property, and somebody sits up there and they're drunk and they're obnoxious and they're smoking. Yeah, absolutely. Absolutely. I think you, for sure.
Okay.
But see, it's not in the ordinance.
I'm sorry?
Yes, ma'am.
It's not in the ordinance. It doesn't
You're
say
saying
the
that
property
homeowners, property owners have the right,
I understand.
but the ordinance, as it's written, it says all beaches can be used by the public. So that's where I'm afraid, and that's with this whole committee, we're trying to figure out what to do to protect the homeowners' rights or the planned communities or the condo owners and all that. But as the ordinance is written, it says the word all in several of the sections. And I'm afraid you're going to have the public tourist who hear, oh, any beaches now we can use. And they're going to be going on to private property. They're going to be coming into the planned communities on condo property. And I think that's
isn't that significantly different than the beach itself, though? If you're talking about going into a planned community or up in the access up around somebody's home, that would not be covered by customary use. That's trespassing today, tomorrow. Is it?
Well, the way the ordinance is written, it says all beaches, and it says it several times.
Okay, but that's not the beach north of the dune, though. From that, unless
It
I'm
says
wrong.
dry
It's the
sand. Dry sand.
Dry sand. All beaches dry
I
sand.
thought the final wording, depending on what you need to clarify that then. So just so we're clear, there needs to be something that shows the parameters of what that is.
Yeah, because as it's written now, it just says all beaches, dry sand.
I thought the last time I read it was south of the toe of the dune.
That's the dry sandy portion of the beach.
Right.
All beaches, but the real key comes in as to the restrictions of what customary use is.
Yes, sir.
And as I understand the ordinance, right now, it's proposing that on all the beaches, these restricted uses of customary use are allowed, whether the property is private or public.
And the last that I've read it, looked at it, that was sitting, walking, sunbathing, those general things, not things like coolers, parties, fires, things of that nature.
Well, anything, and I think it needs to be made clear because there's one sentence in the ordinance that I disagree with. They enumerate about 6 specific things that are considered customary use.
Okay.
And then it says, and any other usual recreational activity. No, that's got
No, that'll have to be defined. Yeah, that'll have to be defined. I don't think.
That's got to go. But at any rate, so, but anything outside of the specific things that the final ordinance agrees to be customary use ordinance are prohibited.
Correct. I do think going back to specificity.
And if those activities, prohibitive activities occur on private property owner would have a right to.
Volleyball. If they set up a volleyball net on their property,
yeah,
you
whatever,
need to take that
or
out.
whatever the prohibited.
Right.
Anything outside of those things are prohibited, as I read the ordinance.
That would be the way, be my understanding too. Ma'am, I'm sorry. Can you go back to because you said something that kind of threw me for just a moment. go back to the planned community thing, because maybe I misunderstood what you were saying.
Well, as in Seaside, Watercolor, Rosemary, the condos who are deeded to the wet sand, they own that, just like private property owners
Yes,
own that. So but the ordinance as it's written says all beaches. And that takes up all the 26 miles.
That's the way, that is my understanding, the way I read
And
that.
so you're
too,
gonna
Sal.
have tourists starting to come spring break, and they're gonna go, oh, I've heard about this customary use ordinance, and now we get to use any beach we want. And they're gonna be going right up into private properties, they're gonna be going into Seaside if they're not staying in Seaside, and it's just gonna, I think it's gonna get out of hand.
You see the expansion past north of the toe of the dunes, what you're saying.
Oh,
'Cause
yes.
I want to make sure, because that
Because the
doesn't-
ordinance says dry sand.
Yeah, okay. I want to make sure, but that really is it's an after effect or a causation, you think, of that. But that's not the specific of the ordinance itself. Going into Seaside, that would already be covered. Now, so specifically, you're talking about Seaside and some of those places which are open to the public coming and going transitory anyway, maybe not
Right.
beach. So.
They're allowed to walk across,
Correct.
but they're not allowed to set up chairs if they're not staying there.
Mm-hmm.
It's a private beach.
Correct. Which the same thing would still be applicable.
But how are we gonna enforce that?
It's the same way, I mean, it's going to be a
Because
challenge.
the ordinance says all beaches.
Correct.
Yes, sir, in Beth Clay, and it also says traditional beach activities. And yet, see, your interpretation was a volleyball net would not be allowed, but it doesn't
It
prohibit.
needs to be defined.
It doesn't prohibit volleyball, it doesn't prohibit frisbees, and it doesn't, in baseball, where the balls go into your dunes, that kind of thing.
That's what I'm saying, that phrase, at least in my opinion, it's got to go.
Yes, sir, and just before that, before it says other recreational, it says traditional beach games. And, I mean,
No, anything that they.
So
It does
just to
say,
be clear,
yeah.
just to be clear, I 100% agree with you from that standpoint. That'll have to be defined, because otherwise you're going to have a deputy or a code enforcement officer, somebody else there going, well, I think yard darts is perfectly acceptable. I've been playing it for 30 years, and so we are going to have to come. You're going to have to come up with as much specificity as you can give. And there'll always be some ambiguity. Let's be frank here for a second. There'll be always some of that. But the more you can do, the better it'll be. Larry?
Maybe, you said something a moment ago about tents or what. Just, I think to be clear, whatever you put in the request and the board ends up including in the customary use ordinance, so, whatever the board may or may not include in the ordinance, whether it's permissive or prohibitive, is simply those things that they find are protected by custom. Obviously, a tent doesn't have any protection of customary use. But now that doesn't mean if you got a rental cottage or a rental house on the beach and I rent it, that I can't go put a tent out if you're okay with it. Mm-hmm. The point is that what this ordinance will contain will simply be those things that the board says has protection by custom. Be if it's walking on the beach, swimming, fishing, whatever it may be. And those things that are listed as prohibited, they're simply saying there is no protection under the doctrine of custom for these activities. Now, that doesn't mean those activities can't occur on any of your property. If you wanted to go in your backyard or back in your backyard and put a tent up, you certainly have that right. Mm-hmm. But the uninvited guest that's traversing your property under the doctrine of custom and the protection it gives doesn't have that privilege. So I just want to make that clarity that the things that are in the customary use ordinance, either prohibitive or permissive, are only those things that the board has found or would find that they have protection under the doctrine of custom. And there's regulations in beach activity ordinance, perhaps otherwhere, that may restrict or allow some other things.
See,
Well-
to reiterate what Larry's saying, only the public that doesn't own the property is allowed to do these very specific things on private property. Beyond that, they're not allowed to do any of these things. The owners of private property can go out and do anything on their property that they want to that is not contra the law.
Correct.
are in contravention of the beach activities ordinance.
They do not have the same right of usage of property as a property.
That's right.
And they do not have the right to deprive the property owner of property.
The doctrine of customary use simply gives the public a very limited stick, as the case law talks about, in the bag of sticks on the use of this property. They have a very colorful way of putting it, but at any rate, that's... But in Louisiana, we used to use the heat of blood to describe manslaughter, too.
Mississippi.
I always thought that was good.
Heat of passion.
Heat of passion.
Yeah. May I ask Larry a question? Well, in light of that, Larry, since number 4 and number 5 in the ordinance discusses what's prohibited and what's allowed, should we not address that? And isn't that part of what the commissioners ask us to do?
I think that is the greatest part of what they've asked you to do.
That's the crux of the whole.
And we want, by the way, we, from our standpoint, because let's be frank here, from all the commissioners aren't going to be down on the beach. So from my standpoint, we really want to know. We really want to know what you think is, what those activities, so that it leaves us out of trying to, or the code enforcement is trying to make that decision about that.
So if a private property owner they look outside and they see a family setting up their beach chairs, their blankets, they're not really disturbing anything, but that particular homeowner, and I do not own beachfront property, I'll make that first clear. If that particular homeowner doesn't want that family there, then they have the right to call the sheriff's department and have them removed.
No.
Let me give you an example of what happened. Let me tell you let me give you the other side of it. So just so you not, and again, this is not my advocating from one position or the other. I'm just simply telling you how it would be enforced and how it's being enforced now. We have a property owner who called on a Saturday, and he was very upset that somebody was blocking his view of the water in his venue. And what have you, said they had umbrellas and those kind of things up there. And so certainly, this person has one of those, what I call the super duper deeds. They've got the GPS marking, they've met the DEP requirements. So under the current law, absent something changing, it doesn't matter whether I like it or don't like it, unless we're told something different, they had to be removed from property. So we go down there, and what you had was nobody on the beach for 2 miles, either way. I mean, I'm exaggerating a little bit, nobody around. And an umbrella about that big over probably a 2-month-old child, like that. They said, I don't want them on my beach. I pay taxes, my beach, I want them off the beach or disturbing me. And I have exactly zero choice in that opinion. They have to be moved. Now, that's the reality. So whether I like it or don't like it, that's where it's at. So it is very analogous to the same thing. You either have the authority or you do not. And that's where we say. So the way we enforce that, I can't walk up to you and go, we've had other cases like that, to be very honest with you. I can't walk up and go, I'm sorry, ma'am, you got a baby so, and the person's sitting here, and guess what? Now I can't say, no, you just get to stay, absent some customary use, right? So that's the way it is, and you either have the authority or you do not. Just that simple from that standpoint.
Do you have other questions?
Yes, sir. Sheriff, I'm reading from Section 2 of the regulation of dry sand areas. Oh, I'm David Bailey.
Thank you.
This paragraph reads, the public's longstanding customary use of the dry sand areas of all of the beaches in the county for recreational purposes is hereby protected. Except as stated in paragraph 3, no individual, group, or entity shall impede or interfere with the right of the public at large, including the residents and visitors of the county, to utilize the dry sand areas of the beach that are owned by private entities for recreational purposes. And as I've said at a couple of these meetings, my concern is this statement tells us what private property owners may not do. And again, the key words are no individual, group, or entity shall impede or interfere with the right of the public at large to utilize the dry sand areas of the beach. And it makes reference to paragraph 3, which describes the 15-foot buffer zone. In other words, my understanding is that it says that the public may not use a 15-foot buffer zone at the toe of the dune. So there is no reference to paragraph 4, which is where the list of things that the public is allowed to do. And so the spirit of my question for you has to do with the meaning of the words impede or interfere. So I manage Rosemary Beach, and we have lots of chairs, as many people observed on the beach. And a typical day begins with, if it's turtle season, my beach staff wait until the beach has been cleared by the turtle organizations. And then we begin to set out a significant number of chairs on the beach. My concern is not knowing what the words impede or interfere mean, because there is no description of what that means, that if I put out a couple hundred chairs on the beach and a member of the okay, well, so impede or interfere does not mean putting chairs out, whether they're occupied or not.
I mean, from my standpoint, that is the way I interpret that. It's you own the property, that's the normal use of the property, that's just the way it is. Now, what it would prevent is somebody coming sitting directly down in front of you that does not own that property, isn't on that property, for instance, and they're going to sit their chair and umbrella, but they can't do that.
Okay.
But they can't tell the property owner how they're going to set up their chairs or whatever it is you guys choose to put up there.
Okay.
That would be the way I read that.
Okay.
Because that would be limiting your ability to use that property outside the scope of what is normally covered.
Okay. Thank you very much.
Okay. Now, I'm sure there's a $500 an hour attorney going to tell me the other side of that, but today that's the way it's going to be. So.
And that's the spirit. My greatest concern here, and I think this is shared by many other property owners, particularly those that have large common area beaches that serve hundreds to thousands of upland properties, is, how does this impact us? Because it doesn't say what we can do, it only says what we can't do, and it's using words like impede or interfere, which have a very broad meaning.
See, now I guess I read that a little bit differently from the standpoint of it doesn't tell you anything that you can do unless you've done something like the fence is the one. Let me tell you what that's about. That's about a fence.
Understood.
And
my
preference, short of that, I don't know what.
Yeah, my preference it would say is that nobody can put up a fence on the beach. Yeah. If that's what,
or
that's
you
the
say
intent
hire
of it,
security
let's say
guard.
in plain language.
What that is specifically and what that is trying to address in general terms is somebody standing security guard checking IDs as you walk across the beach or putting up a fence. Bottom line.
Yeah.
So I mean that's what they're trying to accomplish with that terminology. Could there be a better terminology? I'm sure that somebody will.
I mean, let me so let's say very real example. I'm not trying to come up with outlandish stuff. Very real example would be we come across some folks that are sitting in a set of our chairs on the beach. My security officer can't ask them?
Absolutely could. That's not impeding. That's clarification.
Okay.
From my standpoint, impeding would be
if they're sitting in their own chairs.
Yeah, they're sitting in their own chairs, but I wouldn't see it that way.
Okay. All right. Thank you.
Okay, Sheriff, can you entertain a question from the audience?
I am not paid by the hour, so we'll just go with it.
All right.
Yes, sir.
Hi, Sheriff Mike DeRose. Question for you. If a group of people were to come to the beach, and
Sir, can you speak to the podium so we can get on record, please? Thank you.
Sure. Good evening, Mike DeRose. Sheriff, thanks for your time. Question for you. Let's say there's a group of people that get to the beach before the chairs are put out in the morning, and they set up their private umbrellas and chairs themselves, and then you have a beach service that is trying to put out chairs subsequent to when public has then, what happens then?
So, and again, these are all, every circumstances dictate tactics, but if you're asking me, I would say you'd have to tell them to move their chairs and umbrellas for two reasons. One, that's not covered under customary usage for them to bring umbrellas and chairs down there unless you read something that I haven't read. So no, they don't have the right to come sit up in front of her. Just say, for instance, if you were at whatever open community that may be, or where it is somewhat semi-open, no, they couldn't prohibit you from the use of that property the way you normally use it, and your vendor who's already licensed that you've taken care of to do that with. But just not to be arbitrary and capricious, by the way, we deal with other property owners arguing against each other in these common areas about where the chairs are supposed to be too. So, and we have to tell them kind of the same thing. In other words, they don't like where the chairs are set up at Rosemary, for instance, and they're property owners as well. So,
yeah, the interesting case, I'm in Sandestin, and I've had a lot of discussions with individuals throughout the community who are beachfront, and I'm a beachfront owner, recorded deeded, right, and we happen to have a Hilton a little bit down the way, because we do have guards at the front entranceway off of 98 coming in. So I said, doesn't that help us? And the comment has always been yes and no,
what people have been doing is they say, we're here to stay at the Hilton, the guard lets them through. And then what happens is in busy season, you get a bunch of people saying they're staying at the Hilton, they go there, then they start flooding up the entire beach. That is fact.
Yeah, but you're also talking about two separate issues. You're already talking about them trespassing on your property before they get to the beach. So they're not walking through the beach to trespass. They're coming through your guard shack to trespass. So they're already committing, if you want to be technical, they're already committing the crime of trespass in that's even separate. They're already not following. So
we have a right then, you're
you
saying if we could, so once they pass that front guard gate and they've, I'll say fraudulently or misrepresenting themselves, right? And then we were to say, we could ask those people to be removed?
You could trespass those people from your property.
Okay.
Does that make sense? Not necessarily from the beach in and of itself, but certainly for any property that they've walked on to get there. And even that would be there'd be an issue even them being on the beach once they have crossed your property to get there fraudulently, if you use that term. It's not actually trespass on your property.
Yes.
Yeah, you absolutely could ask their ID. You could have them removed from that property, certainly.
Okay. All right.
Now, let's add the converse to that. They enter the beach somewhere else at a public beach access and walk the mile or two down to where your beach's at. No, at that point, under customary use, they could walk past there, they could sit there, they could swim, and I'm just thinking that's the only thing I've basically listed at this point. But I use Rosemary Rosemary is kind of a good example. It's going to be kind of difficult. They got to find somewhere to park. They got to find some kind of access, and they got to march down the beach to get there. You still have, nothing defines you from. Same thing with even Seaside. Nothing prevents you from determining how that property is used, the upland property, from that standpoint. For these communities, I actually think it's going to be a little, I don't want to say difficult, but I think it is difficult for the public to go into water sound. Where are they going to go in at? Unless they slip past the guard shack, which is already trespassing, they're going to be walking miles to get down there, or a couple miles to get down there anyway. So nothing gives them the right to cross your property to get there. So I don't know if that, Mr. Charles, that answers.
The difficult thing is.
All right, is there a
Sorry,
specific
thank you.
Wait, is there a specific question? If you have a specific question of the sheriff, ask it. We can get into these, what ifs all night long, okay? And we can't sit here and entertain hypothetical issues.
Just real quickly, if I can, when you think about context of customary use as the board has moved it forward, think east-west. Nothing north-south is covered in this ordinance that would give anybody any right to access the beach through your property, across your property, around your property. Lies from the toe of the dune to the water's edge. And that's the only thing that this ordinance contemplates has been customarily used. So anything moving north and south is not covered under this ordinance.
And is already currently not covered.
Right.
Correct. It's already prohibited.
Any other questions from this?
Thank you.
Yeah.
Richard, Bryan, do you think that recording digital surveillance would be helpful to the sheriff's department?
So I want to be clear, Mr. Bryan, in what capacity?
Well, if you came out and whatever activity was going on.
So listen, if you're in the whole issue of being in public, surreptitious recording as it regards to conversation is really the big issue. So in other words, if you think there's behavior that you think is, for instance, trespassing and north to do, absolutely. If you have that, I'm not really a fan of just having, I'm an advocate of cameras where they're provided, but also respect people's privacy and those types of things. But on your property, certainly, if you wanted to do that, that makes sense. And if you thought somebody was doing something that would provide evidentiary value for dealing with, that's something to consider as well, too.
Okay, any other public questions of the sheriff?
Bob Brook. Thank you, Mr. Chairman. Sheriff, 2 questions, please. Number 1, if what ends up being a violation of the customary use restrictions, if it's enacted, does prima facie evidence, if there's a deputy or a code enforcement officer observing that, is prima facie evidence adequate to issue a citation or a warning rather than having a complaint from the property owner?
Yeah, prima facie would indicate that they saw it. So yes, absolutely.
Okay. And number two, if you have a complaint from a property owner, does your standard operating procedure for proof of property ownership still apply?
I don't think it has to under customary use. Quite honestly, that's kind of one of the issues here. Just so we're clear about what he's asking, he's saying, do I have to come down there with the deed and the GPS surveys and all those things? If we're talking about just normal, what you define as customary use, I don't think it's necessary, because it doesn't matter who owns the beach at that point. It's the county will be the victim, for lack of a better word.
One third question, if I may, please. And this is just, Sheriff, I'd just like your opinion, because one of the big issues, I think, for beachfront property owners is what density is permissible of the public using your beach property. Do you have a rule of thumb, a sense, or anything you would recommend as to how many people create a nuisance on private property?
I don't know how I could reasonably, to be honest with you, ascertain that or define that, other than to say this. One of the justices many years ago said, I can't define pornography, but I know it when I see it. So, I guess the short answer for that would be, if it becomes so upon the ground, there's so many people that you can't walk, you can't get to the water, they're blocking your grass, I would think that would certainly be. If you had a Sandestin crowd, if we're talking about that for just a second, if you had a Sandestin crowd piled up behind your house, that, somebody's trying to have a party, a wedding on your private property, something like that, I think we could clearly deal with that, but otherwise, I wouldn't want to attempt to do that otherwise.
So if you couldn't enjoy the use of your private property?
If it was a reasonable, again, I have a gentleman that told me one baby under an umbrella violated his use of his property. There's going to have to be some kind of balance when we get into some of that.
Thank you.
Thank you.
Any other questions of the sheriff?
You get what you pay for.
We really appreciate your time and your information, sir.
Thank you so much. If you need anything, obviously, Audie Rowell, here's Captain Rowell's in the back. He's our South End District Commander as well.
Okay, good.
And, obviously, we want to help you, but as judges, you know, you change any one's fact, you change the circumstance of it.
Yeah,
so ultimately, whatever you decide, we do appreciate the specificity, and we want to work with you. We don't have an opinion in the issue other than to do what is most enforceable and most easy to provide.
Sure, appreciate your time.
Thank you so much, guys. I appreciate it.
Thank you.
Okay, what we're going to do is take a break. We've already passed a motion to agree to have us give our individual opinions about this ordinance. And we're going to have plenty of time to do it, so I don't see any reason that we can't allow each member of the committee 15 minutes to think about their positions and what they want to do and what they want to say and what they want to do in the way of offering a resolution or adoption. So let's take a break for 30 minutes. Okay, it gives us all the time to kind of recoup and go to the bathroom or whatever we need to do and be thinking about what you want to do. Then we'll go with these individual opinions, okay, starting with okay?
Mr. Chairman, are we not going to get to the questions that were queried of us last week? That's at the end, perhaps?
Oh, yeah, that can be part of your, of the questions, that can be part of your reasoning and your thinking, okay?
I didn't know if that was going to be maybe
Yeah,
later.
we're going to all have plenty of time. But
Could we maybe make our little break only 15 minutes? Would that be okay?
yeah, it's fine. 15 minutes. We'll see you back 1:45.
Thank you.
It's also got the timer going, so everybody will know
Okay.
about how long they have to speak.
You're good? Okay. Mike Sturban. So as I was saying, I'm very grateful that we're talking about this. I know we have some disagreements amongst us, and the community clearly has some disagreements about how to go forward with regard to preserving customary use in Walton County. It's very important, and we can see already that the mood of the community and our interactions with each other have been affected by not addressing this issue so far. So while we may be reluctant to exactly how to move forward with it, the need is definitely there, that we would finally address customary use in Walton County so that we can preserve that use. So, and I think it's really important as we're working together that we understand that what customary use is preserving something that has already existed, something that even if we go back to the ancient times, people have been using the beach for a variety of purposes. In more recorded history, many of those uses in recorded history have been recreational. And to this day, people enjoy using the beaches. It's what they come here for as tourists, and it's what many of us came here for to live here. So this is, it's really important that we realize that this is not something new, customary use. We are affirming something that is ancient, something that is old, something that has been going on for a long time. I think we do have some things to consider with regard to how to enact ordinances and the beach activities ordinances about what activities might be acceptable and not acceptable. I think the sheriff has given us a good explanation of his abilities to enforce and to keep the peace, which is appreciated. I do think that customary use ordinance will help our law enforcement to keep things peaceful and to assist both the public using the beach and the private owners using the beach, making sure that that everybody can have those opportunities to use the beach that they're used to. I think that it is important that we look at the language of the ordinance to make sure that it will be able to stand. And so there may be, I'm glad that all of us will be providing some written record of recommendations to the county so that we can make sure that the ordinance as passed is going to be effective and will pass scrutiny, legal scrutiny. I think that's reasonable that we're doing that. So even though, I definitely fall on the side of promoting customary use, and I'm very for this, I'm also for a strong ordinance that doesn't go too far so that it becomes ineffective or shot down in the courts later. So I do appreciate your comments, and I think where we can come together on those things, the county will benefit from our work. So, maybe that's enough. Yeah. Okay. So that's enough. Can I reserve 2 minutes?
Yeah. How much time?
I've got 11 actually.
How much time has he got?
All right. I'd like to reserve a couple minutes if I think of something else. How about?
Well, I'll only be able to other words.
That mic's real sensitive. We've got to move it by the base. Grab it by the top of it.
You can use part of your time and then come back and reserve another part of your time, okay? Out of 15 minutes.
It's always harder to go earlier, but I'm going to do a little blend between the questions that were given to us last week and then also addressing our task at hand here and try to do it quickly. And the first one was, again, about the inevitable erosion. And I would like to, that goes into one thing that I would delete would be the 15-foot reference. But let me back up and say I support the Walton County Board of Commissioners customary use ordinance, and I'm so pleased that they have passed that and that it go forward. But this has been a good exercise to further define, to allay any fears that might be out there, and to help fine-tune it as we can. But one thing I brought a fossil. This is from Aliquot, and this is Aliquot. It's not the Aliquot that you may know at Freeport. It's where the first county seat was. And so the shoreline used to be a lot farther north. So the question was inevitable erosion. There has been, and there might be again. So, and in that sense also, 10,000 years ago, the shoreline was 100 miles out, and it was receding at 24 centimeters every 100 years. Then about 3,000 to 5,000 years ago, it slowed down to about 4 or 5 centimeters every year. And that's what gave us the beach that we know today. That's what maybe helped the coastal dune lakes develop with our beautiful white quartz sand. And I actually have a sample of the sand from the 1970s. And here's a piece of quartz rock quarried from the Appalachian Mountains from which our sand comes. And then also a clear one, so that our sand is very different as far as when you think about how it's silic glastics, it's SiO2. It's not calcium carbonate. And I know one person spoke last week about the restoration or whatever. If you bring in anything to our beach other than SiO2, the silic clastics that's come from the Appalachian Mountains, it's wrong. I mean, so I would not be for anything ever being put on our beaches other than that. And so that's that. But so going back to, 4,000 or 5,000 years ago, our shoreline or beaches that we have now stabilized, and that opened, that way the lakes could open and close. And that references Britton and Morton, and that's the shore ecology of the Gulf of Mexico, and that's from University of Texas Press, 1989, page 30. And then also about the sand that you can read about our SiO2 and our quartz sand, that it was that late Oligocene regression that you had Randazzo and Jones in the Geology of Florida, that it talks about. It was just a major epic event that gave us our shoreline that we have today with the sand that we have. And so that's Randazzo and Jones, the Geology of Florida, 1997, page 61. So just to me, customary use is global, nationwide, worldwide, but again, just how special, our sand is, because just answering some of the public's comments about coming in and maybe wanting to bring in sand or whatever. I wanted to address that. Okay? So that's that. On the question of inevitable erosion, there is, and the next hurricane may, that's again why I'm the 15-foot, I would take anything out of the customary use doctrine that the language might not stand in court. So I'm concerned about that one. I'm glad the county recognizes customary use. About the economic benefit, there's been some talk about that there are 800 to 900, I guess, Gulfront property owners, where there's thousands and thousands of upland private property owners that when maybe combined, like even around, say, Eastern Lake, maybe there's 30 or 40 homes that are, well, some are a million, some aren't. It varies. So, but I believe that if we did not have customary use, it would be catastrophic economics for the county, because those people also pay property taxes and have jobs and everything. So to me, that was a point to debate about. Yes, there's value in all of our properties. That there's the 800 to 900 Gulfront property owners, but then when there's just 800 to 900 property owners just around Eastern Lake, and you start doing the math, I mean, there's people in Paxton that own beach property, or something not on the beach, but so the economic thing was maybe a wash or something we could have debated. I think the case law appears to support customary use. And well, just one last neat thing, then I'll go to a few other things. Private owners of upland have the huge economic impact. And I have a 1931 Walton map, and it has the neatest saying on it. It says, "Where the highlands meet the Gulf." So we have long been a county where the whole county, like the whole county, where it was the highlands in the north end, where we had the highest point in Florida at Britton Hill at Lakewood Park, which is 345 feet above sea level, which is the lowest high in America. Really neat things. And then we have our beautiful forests and the Choctawhatchee Bay, and then we have the coastal uplands and forest, and we have the beach. And so it's the whole county has long loved the whole county, and so to want to make sure that we have customary use of our beaches. But the beaches are different, and from that I would go, and the beach is different, and the courts have said so. And the public has use in perpetuity. I agree that the Florida court has already ruled on customary use, that it's been approved for over 40 years, that there is a heavy burden not to have customary use. And again, what would happen if we didn't? Again, I think the economic impact would be severe because there's so many more people that pay taxes that are on the beach than are. And the whole bit about being tax-free Florida, again, that's a real draw to the area for people to come. And so that would be something I would think, I guess, not think. Perhaps the court would consider that aspect. And so the language, it needs to just be able to stand. And I appreciate the opportunity to speak and be with this group. And I think we've made some progress. And that's it for now.
You want to reserve the rest of your
May
time?
I reserve a minute or two later?
Reserve however much you got left.
7 minutes and 45 seconds.
All right.
Okay.
Get it over there, man.
I can, thank you. Mr. Chairman, thank you. Beth Clay. I feel like I'm in kindergarten after hearing the historic presentation, so you'll just have to forgive my lack of institutional knowledge. I'm here and I am concerned about the ordinance as it's stated. I believe that the county commissioners were somehow pressured in a sense because of some of the tales that were going around about outlandish landowners, and I understand that there are some. However, I think that they are not convinced that the ordinance as it stands is perfect and that we should rubber stamp it, or we would not be in existence here tonight and trying to come up with some reasonable alternatives. I feel that they asked us and we agreed to look at the ordinance and to make improvements to it. Had they not wanted us to address number 4 and 5, I think they would have never created this committee. So I think that we must face the challenge that they have given us and that we accepted, and that we should look at number 4 and number 5 in the light of what can each of us give. And I realize that in our meetings before, we all have different ideas, we all have different interests and needs, and actually lots of our livelihood depends on various interpretations of it. But I feel that we should spend our time looking at number 4 and number 5, and as much as we want to debate whether customary and ordinary use is good or bad, that's not what we're here for. We're here to do what the commissioners ask us to do, and that is to try to come up with some additions or deletions or whatever that would make the ordinance that they passed better and make them feel that it is a more perfect document to put in effect for the county.
Okay, so we reserve the rest
And
of
I
your
would,
time.
thank you.
Okay.
I don't know where to start. Heard both sides. Chuck Schneider. I'm probably a new kid on the block. I think I've said that before. Been here actually less than a year, moved to Seagrove. What attracted us to the area, and we had looked all over Florida, everywhere in Florida, through the Carolinas also, going on up the coast, and found no place like this place. Fell in love with the area, fell in love with the beaches, fell in love with the green ocean, the emerald green coast, so to speak, and just really attracted to it. We ended up buying a lot in Seagrove and building a home. Like I said, been here less than a year. What else attracted us was rosemary, seaside, watercolor. That's about as far as our little space goes. And what attracted us to that area is that the people were exceptionally friendly. Nothing like the folks we left in Chicago. Dramatically different. The shopping, just the ambiance of the area, the warmth of the area, being able to ride your bike and go around and driving a golf cart. I know you can't in Rosemary, but we can up here. All that taken into account, and also looking at the properties, looking at what's around, what's on the coast, what's on the other side of 30A, what's on this side of 30A. and looked at, is this a good investment or a bad investment? I've been at a lot of places in Florida, I'm sure a lot of you guys have, and all over the country. There's not a better investment than right here on 30A. I mean, you make your money. I couldn't believe the escalation of the lot that I bought 4 years ago and what it's worth. I couldn't afford it today. I mean, it's gone up so much. So I think what you have to look at is sort of a holistic thing. What attracts people here? What makes this area so important? What do we have that we can share? And what we have basically is our community. We have this special place, and I can't emphasize that more than anything. We have this special place that happens to have a nice beachfront, that people come here just for that. If they stop coming here, we're dead. Our property values, the people that, I know you own property on the beach, and I think that's excellent. I'm a little jealous because I'd love to have a place on the beach, except, you got a lot more maintenance than what I've got. I'm about 2 blocks off the beach. But if we start cutting back and cutting access to our beach, all of us are going to lose. There's just no way we can't. With Rosemary, we go down there. I enjoy, you got some great restaurants. You got some great places. We walk out on the planks. We can't get access to the beach because, we don't know the code, but we still walk out there and look at it and see all the other stuff. So we spend our money there. A lot of tourists that come here spend the money in Rosemary. They spend their money in watercolor, spend a ton of money in Seaside. Seaside's a little unique because they do have a public area that you can go to, that they give you access, which I think for Seaside, that is an absolutely fantastic thing. Because you've got that court area, you can walk out, you go up to the, I don't know what you want to call that, the pyramid, whatever it is. You can go out to the beach. They've opened up the staircase there, which really makes it nice now. My kids and my family come here, and they totally fall in love with the area. Is that what we're looking to try and destroy? And if you restrict the beaches, you're going to destroy that. You're going to destroy people wanting to come here. Now, things that I've heard, and I understand that the ordinance is not perfect. By no means anything that gets issued is perfect. There are things in here that need to be clarified. There are some specifics that need to be defined. But as far as the ordinance is concerned, I think it's a good thing. I would hate to see it rescinded. I think there does need to be a balance between the private owners and the public owners. I'm glad that the sheriff was here because I really heard him define a lot of things that I was confused about. What are the rights of the private owner versus the rights of the public on a private owner's property? I also heard him talk about, he mentioned, trespassing. If somebody trespasses over your property to get to the beach, that's trespassing. That's illegal. It's always been illegal. So that needs to be enforced. So enforcement is one issue I think that could be addressed possibly within the ordinance itself. Maybe that needs to be a little bit better defined on how the ordinance is going to be enforced. Maybe a statement within the ordinance needs to have something to do with trespassing. The ordinance is talking about east-west, and I heard that, but maybe there needs to be something there within the ordinance to define that that is what it is. It's east-west, it's not north-south. And that if you do cross somebody's property, that is trespassing. Because I think that is an issue with the private owners and also with the developments. Other things that I sort of heard about was, let's see where my notes are. This division that between the public and private. The private owners, you definitely, and this I'm very conflicted because I'm very much of a constitutionalist, and I believe in private ownership. I do not believe in the state having the right to take away your property and make it their own. But what I hear, it's not the people that reside within Seaside or within Rosemary or within Seagrove. The people that reside here understand the beach. It's the people that don't reside here. It's the renters. And I'm sure many of the people, I don't know, just in this group or maybe out in the public, 90% of the properties around here are all rented. I mean, one reason we didn't go into watercolor and look at watercolor, nobody lives there. You know, we looked at Seaside, nobody lives there. Even in Rosemary, nobody lives there. So the better education that we can give to the people that come here, maybe that's the problem. It's not the people that live here or the guy that wants to go down and go surfing on the beach that's been living here for the last 20 years. It's the people that come here and spend the week. They're out there to party. They're out here to have a good time, but nobody defines what they can do and what they can't do. And I put that burden mainly on a lot of the people, a lot of the renters. If you're going to rent your property, you should be sure that those people know what they can do and what they can't do. And the developers, I think the same thing is true. You've got to be sure that the people that are coming into your property don't abuse the privilege. They don't destroy our beach. They don't dig it up. They don't sit, you know, I have a big thing with smoking. I know what it is. A guy can be 200 feet away from me and I can still smell the smoke. I think you ought to ban that on the beach, but, you know, that's my opinion. But that's where the crux of this problem is. They talk about people putting up a tent. You know, I don't like tents. You know, I know down on Seagrove, we were there when, you know, you got Alabama, Tennessee, you know, you got Oklahoma, and you got Georgia tents up there. Everybody down the beach with the tents. You know, do I find that offensive? Not really. Do I find it obnoxious when people are sitting there drinking and getting loud and all this other stuff? Yes. The tents aren't offensive. The people are. And I think that's what we've got to focus on. We've got to look at, like you said, 4 and 5, define what's acceptable, and unfortunately, I hate to use the term, acceptable behavior, rather than acceptable 10-foot tents or, you know, a baby sitting under an umbrella and the owner doesn't like it. It's a behavior issue. And I think we need to address that and figure out how we can build something together that is more driven for the individuals that are here a week and make sure that they don't violate the rules. Because I don't think anybody around this table is going to violate the rules. I'm not going to go out and put a boombox in your backyard because I know what it's like. I know what's offensive to me, but our guests don't. That's it. I'm done.
You have time left.
6 minutes.
Good. You got 6 minutes left in the bank. Good job.
I would still, I still believe that ultimately there's a good likelihood that the courts, that this is the purview of the courts and that ultimately the courts will weigh in on this. However, I think it's in all our best interest to see if we can't come up with some things that we would find acceptable with or without a customary use ordinance. So I have drilled down, frankly, more than any of the rest of you have talked about, because I think that the crux of this working or not is the actual activities that are or are not allowed. So bear with me. If you want to write these down, I'll go slow because I'd really like to know how everybody here, including the audience members, if they choose to participate, feels about these things. Speaking for myself, I believe customary use, to the extent that it does exist or, you know, the courts decides it exists, would include things like walking, jogging, sitting on the sand with a towel or something between you and the sand that's very innocuous, that can be easily carried. Sunbathing, fishing, and building sandcastles. Those are things that are in 4 already. Now, in addition to those, I added swimming, which I think we already, basically, if it's done in the water, it's sovereign rights anyway. So, when you're talking about swimming, surfing, stand-up paddle boards, kayaks, kite surfing, canoeing, whatever else that's done in the water, that's protected by your sovereign, the sovereign rights in the state of Florida. Anything that's reasonably done on the wet sand is already protected, in terms of traversing or that sort of thing. So the things that basically, I guess you could say I added were things like what Mike talked about. If you're doing something as innocuous as sitting there with a camera photographing the stars at midnight, I mean, you're still just sitting on the beach. It's not like you've come with a bunch of stuff or interfering with anybody's enjoyment, peaceful enjoyment of their property, or interfering with any public member's enjoyment. Okay, so those were kind of my drill downs on things I would allow. Now, you may notice that I've omitted some things that were included in here. I think basically anything that is an overhead structure has enforcement issues involved. That isn't to say that, if this committee decides to allow umbrellas or something that, I'm going to have major heartburn over it, but tents or overhead structures such as tents, I would disallow. I would disallow playing beach games, basically that have projectiles or, a structure that like a soccer goal or a net. Anything that you basically are having to set up equipment on the beach or you're using a projectile, I would say is disallowed. And of course, as the judge already pointed out, we don't want similar traditional recreational activities because it's way too vague and broad. In addition to not allowed, some of these are already covered in the beach activities ordinance, but I'm just going to tell you, as I tried to walk back through everything I've seen on the beach over all the years I've been here, I tried to walk back through and say everything I could think of. No alcohol, no smoking, no glass, no bonfires. I'm going too fast, but those are all covered already, folks. Without the bonfire, you have to have a permit, or if you're a beachfront owner, you can get an annual one, but you still have to get it from the fire department. No littering, that's kind of a given. Dogs must have permit and leash and walked along the wet sand. Is a difference that I would like to see, because it's a lot easier to clean up after a dog on the wet sand. It's a lot easier for the sand to be washed down there. And what happens most of the time is they get walked up near the dunes and the dogs are running all over the dunes. And they're not on leashes a lot of times. So every time I see an owner doing the right thing with a dog, I always thank them. Every time, I thank them for having their dog on a leash. I thank them for abiding by the hours. I just go out of my way to do it because there aren't that many of them. And I like dogs. I actually have a dog, but I don't take him on the beach. So, okay, so the picking up their waste is a given. I did include the no games that involve nets or projectiles, including frisbees, balls of any kind, any other flying objects, including birdies to play, badminton or whatever, and that the sand dunes are restricted from all public activity, all, no exceptions. And the only one that I've heard added to that tonight is no boom boxes and loud music kind of stuff. Now, that's pretty exhaustive, I think, and I welcome comments and disagreement or discussion about it, but that's what I've kind of been doing the whole time we've been in this, is trying to drill down to, okay, if I think back to the 70s, what did I used to see on this beach in the 70s? And what I've just outlined for you are things that I did see or things that I did not see. And that's kind of all I have to say right now. So if I have any time left, I might say something else later. Thank you. Okay. Yeah. Oh, sorry.
Well, we all agree this is an unbelievably special place. My family has been vacationing here since my children were little bitty, and now they have children of their own, and we're bringing those children down here. So we've been coming down here forever. When we purchased, we did not purchase beachfront, but we are in Rosemary Beach, and we purchased because we like the idea of a private beach. My main concern, I think there's a lot of good in this customary use, but there's a lot of bad also that needs to be tweaked. My main concern is the private property's owner's rights, which is not really addressed in here. After the 1974 ruling, the county, and not only Walton County, but all up and down the coast, they continued to issue county-issued building permits for condos and private developments and private owners that were deeded to the mean high tide, which went against everything that this 1974 ruling said. So if you go back at this point and try to change all that, you can't change the deeds, and you are taking away, the government would be taking away, or whoever, the county would be taking away homeowners' deeded property, their private property. So we have to come up with some way to keep the homeowners happy, the public happy, and I think the first thing we need to do is in this ordinance is remove the word all beaches. To me, you cannot say all beaches and then you have homeowners and developments and condos that own to the wet sand. I don't know how we get around that, but to me, if they took out the word all, that would be much better. I think we do, as we've seen tonight, speaking with the sheriff, I think he's 100% right. We as a committee need to, and as Lisa, your list was wonderful, we need to be very detailed and very specific on what's allowed and what's not allowed, with remembering that if a homeowner decides, I do not wish to have anyone on my sand this afternoon because my family's going to use it, they have that right to tell those people to leave or to call the sheriff. When I asked that question to the sheriff, everyone said, no, they don't. They wouldn't have that right. And I disagree with that completely. The state parks, I've said this before, I feel like that is a wonderful place to begin. If we eliminate the fee, I tried to get into a state park one time because I just wanted to walk around and enjoy the beauty. And I forget what the charge was, but if you take away the fee to get into the state parks, I do believe more public will use that and just call it a state public beach. But the county's going to have to step up and either make that happen or buy more land, beachfront land, which there's still some available. And, you know, Governor Huckabee mentioned one night, instead of using millions and millions and millions of dollars wasted on litigation, use that money elsewhere. Make more public beaches, buy more public land, and allow that for. But I just keep coming back to the homeowners' rights. I am concerned how the Sheriff's Department is going to enforce this ordinance because it's a huge undertaking. I know what I have to send out to my renters, and I guarantee you're not going to get homeowners that are going to send the 22-page beach ordinance and everything. You can tell them to all day long, and I don't know what they'll do. And I don't know that the renters, you know, I make my renters sign, I have about a 5-page, very detailed, almost a legal document that they have to sign and acknowledge my rules. I don't know that they really will read it if you don't make them, you know, they could sign it and send it back to me. I don't know that they're reading it, really and truly. So that's a concern, is how they're going to enforce all this change. How do we let the public and the tourist know what exactly they can and cannot do? I think in this ordinance, I believe it was passed way too quickly. My husband and I were at a meeting a year ago regarding this, so I know it's been in talks for a long time, but then all of a sudden, boom, we have an ordinance. And I don't think the public, I have a friend who owns 2 places down in Watercolor, and I called her about this. She said, what are you talking about? I've never even heard anything about it. So there's homeowners that don't even know this ordinance is getting ready to take effect. So I think it was passed too quickly, and there's too much of the unknown. I think it needs to be defined a whole lot more. One person, I don't know whether it was one of you gentlemen, might have mentioned this in one of our previous meetings about the Army Corps of Engineers has offered to expand the beach. They've offered this for years and years and years.
That was a gentleman
Okay.
that's not here.
Okay, that to me sounds like a wonderful plan. If we could expand the beach, then we don't, because there are places that have been eroded and you don't have as deep of a beach in certain points. If they could do that and increase it, then maybe you could do a specific, so many feet buffer, and it wouldn't make the homeowners that upset with having to give that up. I think that needs to be looked into, definitely.
We'll explain that one to you another day.
Like I said, I don't live here. I wish I could live here full time, and someday I hope to retire here. But anyway, those are my concerns. My soapbox is the private property owner's rights in this ordinance.
You have time left.
Yes. I'll reserve it.
We're all good.
Yeah.
Thank you, Judge. May I proceed? Okay. My name's David Bailey. I just, there have been a couple folks who have commented what their first experience here was like, and I had one that is, to me, today, looking back, was pretty funny, so I'll share it. And that was, as best I can remember, it was about 1987, and I made my first visit to Grayton Beach to stay with a couple buddies. It was probably about 8 or 10 of us, and we spent a nice weekend, and primarily we were fishing and surfing. And I actually fished during the middle of summer from a Jeep on Highway 30A at Alligator Lake from the middle of 30A for probably an hour. That was how light the traffic was in 1987. So, pretty neat place. A lot. Now, the spectacular thing to me is that there's still that character still exists here today, even with all the pressure we have. But I think what we're bumping up against is there is a limit. There's a day that the human-scaled, diverse, and very fragile communities will no longer be able to support an unlimited volume of development and tourism, and that the quality and quantity of public beach access is vitally important if we wish to preserve some of this character. So I've got kind of thoughts that I had from prior meetings that didn't come up for an opportunity to share, so I'm going to kind of bounce around to 3 or 4 different topics. Just at this meeting, I've written down the following thoughts. I am for better and higher quality access to the beach for everybody. That's both private owners and the public. I'm very disturbed that the ordinance is written is so hard for a property owner, a Gulfront property owner, to understand. It's very difficult to understand. The sheriff that was one of the more assuring answers I've heard in this entire thing, that setting out beach chairs would not be considered an impediment to the customary use of the beach. I've said before, I'm also disturbed, and this is a sort of official statement, official position that I represent, and that is that I am disturbed that the way that the ordinance was adopted does appear to be improper. Again, the courts will figure that out. It's certainly wonderful that the public's assurances of what will come to pass if customary use stands. There's that open-ended statement, that sort of captures anything that was forgotten or left out. No problem, we'll tuck it there in the end. I hate to say that I have a problem with it. I only have a problem with it in relation to the fact that it's so difficult to understand what the private property owners will be able to do. I believe that a much larger plan is needed to provide truly high-quality access to the beach. I know that there has been some study by the county and others, the TDC, but I think that we really need to take a step back and look at the larger community, look at where access is good, where it's perhaps wonderful possibility. I mean, Grayton State Park is the one that I use, I've mentioned before, and I think it's a wonderful place. I don't want to see it overburdened. I know that the Rangers, they've got a tiny budget to take care of a large piece of property. I can't imagine that they would be excited about a lot more people using it unless their budget increases, and so they can handle it. But certainly that's something that it'd be good if the state and the state parks were involved in this dialogue. To my knowledge, they have not to this point. I think some of the dialogue back and forth on both sides, we're both taking some liberties probably with some of the facts, or maybe the spirit of what we're talking about. I'm not picking on anybody here, but Brenda, I'm just something I wrote down. You mentioned 800 or 900 Gulfront owners. Just using the 3 communities that I know the numbers on, Rosemary Beach, Seaside, and Watercolor, there are actually 3,000 owners who use that common area beach within those communities. So, it's not just a couple hundred owners holding the rest of the community hostage. Many of the beaches belong in undivided interest of thousands of owners. When we've looked at this ordinance, the bottom line is with ordinances, and they're pretty down and dirty documents, and there's 3 pages here, but really this ordinance comes down to section 2, which is 5 paragraphs. All the whereas language is really just kind of fluffy language at the beginning of it. However, fluffy language is sometimes inspiring, so I wrote out a few whereas clauses. I thought, and these are really the spirit of these is what I was after. I mentioned previously that there's only one whereas clause that really talks about private property owners' rights, and the rest of them kind of get down to the business of opening up the beach. Whereas the unique human-scaled patterns of development and the thoughtfully modulated relationship between public and private property in Walton County is an inseparable part of both the local small-town culture and the economic foundation of all of Walton County. And whereas making broad and overly general proclamations regarding such a unique collection of communities has the potential of threatening the aforementioned cultural and economic foundation. And whereas the Walton County Board of County Commissioners wishes to provide for a variety of meaningful and useful ways to access and enjoy the beaches that promote and benefit the public interest, private property rights, and the local economy. And whereas it is recognized that the private property owners include individuals who own single-family residential lots that front onto the Gulf, as well as larger parcels of an undivided interest of hundreds of upland owners, and again, I just corrected myself, thousands of upland owners, and that each condition is unique in its ability to carry the additional burdens of open public use. I think we need a funding mechanism established as part of this ordinance, or an ordinance, that provides for not only public beach access through the public ownership of leasing dry sandy areas, but also of the upland amenities such as parking, restrooms, and access to food and beverages to minimize the intense burden that the public use of the beach without such amenities creates on both the dry sandy beach and the upland areas nearby. I think we need to answer questions like, what caused the county BCC to adopt a customary use ordinance at this particular point in time? What other solutions to the perceived problem exist? That partly has the answer of what the beach renourishment project was. And from my perspective, this was the concept of making the beach wider. Step 1 was put a 50-foot wide dune on top of the private beach and then create a public beach outboard of that. The quality of the sand was an issue, a variety of issues. But if step 1 is eliminate private beach, sorry, got another big problem right there. So, has there been study of the potential impacts of adopting the ordinance as presented? Is there a significant downside to delaying the implementation of the ordinance? And then, I'm sorry, some of these are disconnected thoughts, but moving forward, staying the ordinance for 2017. Waiting to see how the adoption of the ordinance should properly occur, whether it's by legislative act or judicial act. Studying the problem a little bit more, defining it, trying to solve it. And one of the things I mean by that in all of this conversation, and some of the comments I'm making probably stand a pretty high risk of offending people, but this is just thoughts that go through my mind. I've heard and I listened in alarm at statements on both sides of the kind of behavior that we all have had to put up with. People slapping cell phones out of people's hands, people putting sticks or batons in people's faces, people asking, I'm assuming the baby was accompanied by at least a parent, so the baby having to move, a couple people sitting on a beach that was otherwise unused. And these are really disappointing that people in our community would act that way. That escalation of bad behavior is one thing that seems to have led to this conversation. Another thing, and this is the comment, I hope I don't make a bunch of enemies out of this one, but it's The rise of the delivery vendors on the public beaches also seems to have paralleled very closely the escalation of this conversation. I've lived in a couple different spots on 30A after moving here 8 or 9 years ago, and at one point I lived near the Gulfview Heights access. After the first couple of years I was here, it just didn't seem like there were that many chairs being brought down at that public access and placed on the beach. And I was down there both surfing as well as taking my family down, kind of alternating. And so some days I was down there just as an individual. I just came down to walk over, went out in the water, surfed for a couple hours, came back, used the shower. I was glad to have the restrooms and shower there. That was good. That was nice amenity. The days I went down with my family, it was all of a sudden I started to realize, wow, these tents. And the next thing you know, part of the access gets filled up with delivery vendors, and it just seems like all of this activity is just escalating rapidly. In that area, it didn't seem to parallel the construction of homes. There's not been that much construction activity over the past few years there. And so I've been thinking to myself, why now? Why is this thing ramping up? In other areas of the beach you go to, and it's obvious it's construction, new developments or homes being torn down and multiple more bedrooms being built. But as I started thinking about this, I don't know what the answer is. I don't know what's causing the problem, and I don't know what's going to happen when this ordinance is adopted. And that scares me, that our community is just kind of fumbling along in the dark, and that none of us know really what's going to happen. And I know that the appeal to stay the ordinance probably comes across as, well, yeah, he's anti-customary use. Of course he wants to stay the ordinance. But I'm saying that as a member of the community who wants to be here for a long, long time, and I don't want to see any of the outcomes. I don't want to see the non-Gulf front property values diminished. I don't want to see the Gulf front property values diminished. I have my ideas about how the property values relate to each other, but I can't be 100% sure of that. And so to me, taking this action without more certainty is concerning. So that's my rambling batch comments. Thank you. And I'll save a minute of it or something, and I'll donate my time to anyone else who needs it. Mm-hmm.
Okay. Well, I think customary use's time has come in Walton County, because this isn't the first time it's come up. I want to say back in 2008, it was talked about in Walton County at the time. The commissioners said, well, this is a hot potato. We're going to toss it down the road, and they did. And so we've got to look at it. I don't think this is a perfect ordinance, but I think it's something that we need to move forward with. And if this committee can craft something or give some recommendations that can improve it, I think that's great. And my specific recommendations to improve it or make it, have better standing would be, let's see. First, any language in here, again, I'm not an attorney. I think the judge had some really good comments about some of the language, and I think one of it was, correct me if I didn't make good notes, but the whereas number 6, I believe you wanted to change some of the language to recognized and protected. So I'd like to see that added in at that point. Then I've made this suggestion, and how it could be done, I'm not sure, but take the 15-foot buffer and add it to the activities ordinance, so it kind of cleans this up, and then at some point in time, if 15 feet doesn't work, maybe it's going to be easier to adjust it, make it smaller, make it bigger in the activities ordinance would be the better place for that. But I think there's a lot of good reasons to have that 15-foot buffer up against the dunes. But we need to define customary use as maybe the right to the toe of the dunes, because when I did all my reading on customary use, it was always to the dry sandy beach was always defined as to the toe of the dune or to the vegetation line. Then I want to talk about some sort of like what Lisa did down there with the specifics in On page 3, number 4, I'm not going to go, I'm going to say, yeah, well, I believe we are walking, jogging, sitting on the sand, in a beach chair. I've kind of, I like my little aluminum beach chair because I can get up off of that easier than beach, okay? But I don't want to see those big giant chairs that the vendors bring down. So if there's a way to craft language that would say, privately owned beach chairs, not the vendor-owned beach chairs, like I say, that's tough. How do you define that? But, small aluminum beach chair. But I think that is something that could be more specific. Yeah, beach towel blanket. I think a 10-foot beach umbrella is unwieldy and unrealistic. I should have measured that out at home, but I didn't. But, typically, I believe a beach umbrella is 6 to 8 feet, and I think 7.5, is that right? Okay, well, we can say, I think that needs to be a smaller number, and I'm not going to say exactly what, but I do think it needs to be, again, maybe 7.5, 7, 6, but a 10-foot beach umbrella is just going to be a problem for everybody, even the owner of the beach umbrella, Yeah, the playing of beach games. I've seen people come down there with that new thing that they do, and they're throwing stuff, and they take up the whole beach. I don't know if you want to be specific with the projectiles or not, or just strike playing beach games. I don't know if that's a little bit too militant, but I think those can get obnoxious, Building beach castles, great, and then strike that in similar traditional activities, just strike that. So I think, and again, the sheriff really cleared that up, that this is what people can do, but it's not restricting the beachfront property owners from doing anything else that they want to do. That's my understanding. Correct me if I'm wrong. If Lisa wants to go down and play whatever that game is where you throw stuff, she can do it because it's her property. But I can't do it, okay? And that's okay. Some other things that folks had mentioned. I like this. I like the idea of getting rid of the tents. I think it's not just the behavior. I've seen too many times people come down and that's their camp for the day. They bring 2 and 3 of them, and then they just take over. I think and then they don't even offer shade because the sun moves. Your umbrella, you can tilt it and you got the thing, because then what happens is really they've got the tent, and then I have to set up over here because the sun is really, the shade's not under the tent. So I think their tents are obnoxious, and I think they need to go. So smaller umbrellas. Okay, I'm just going through my checklist here. I agree with when he said ban smoking on the beach. You can think, God, I think that's a great idea, because I'm like you. I'll stand on the walkover, which I would walk over. I'll stand there, and I don't even hardly see anybody, but I can smell it, and I'm like, that's not part of my. I want to smell the salt air. I can imagine there's places where, 10 years ago, we never thought, what do you mean you can't smoke here or there? But it's happening, and it's just, I think that would be enforcement on that one, but good. But, I think that'd be good in the loud musical devices. Just, I don't know if you want to call them boom boxes or what, but I think those need to be banned because, again, I don't want to hear your stuff, Put earphones on if you really got it, and if you don't want to hear the sound of the waves. And I think the key to this, the sheriff said it, and I think we need to make a recommendation as a committee on education. Education is going to be paramount, because I'm hearing stuff from the audience, I'm hearing stuff from people on this committee that it's like, I thought were common knowledge and they don't understand, So education is going to be really, really important. And I'll tell you what, I want the sheriff to do a video. I want him to do a video and talk about it, because I think that's one way. You're right, people don't read stuff. I don't read stuff, I just check it. But you know what? They'll sit and watch something, they'll watch it. And so I don't know how you get it out there, but I guess they don't use VCR.
They can have a podcast, they have to push that and accept after 3
Get the
minutes.
SOA people to do it or somebody, but you know what? People will watch it. All right. Let's see, where am I here now? That's basically, again, in the ordinance. I think we need to, if at all possible, this committee needs to say, let's make this a good ordinance. Let's tweak the issues that are issues for people, and then recommend that we put have the county, the TDC. TDC's got a lot of money. They can make some fancy videos, and get that out there. I want to make some comments now because I've been here since I vacationed here since way back in the 80s. Stayed on just about every beach. Ended up camping in the state parks because I lost my good paying job with the oil company and then actually moved here in 1990 because I figured if I was going to be unemployed in Louisiana, I'd just as soon be unemployed at the beach. And so I got very involved with the state parks. I've been involved with the state parks and the forest for a long time. And the county can't tell the state what to do with their state parks. They have their own governance, they have their own management plans. And so what the TDC did and each one is managed differently by a different set of plans. And the Topsail Hill has they worked out an agreement with the TDC, and every summer they pay $25,000. And I don't believe they've ever, and they said, and if we use that all up, we'll renegotiate, but I don't believe they've ever used it all up. They asked Grayton Beach if they wanted to participate in that, and Grayton Beach says, no, we don't want to participate in that, we don't need it. And the state parks have something called a carrying capacity. When they're full, you can come up to the gate and they say, sorry, we're full. And I don't know that that's ever happened at Topsail. I believe it has happened sometimes 4th of July at Grayton Beach. So the state's doing a beautiful job at our state parks, and I appreciate that. But the county the county can talk to them, but the county can't go and say, you're going to do this and that with your beaches, or anything in the park. And then another thing I want to talk about, the beach renourishment, because I was very involved with that when it first happened in Panama City. There was a guy, Jim Thien, he used to come and he'd say, you got to go see those beaches, they look horrible. And I was like, oh. So one rainy day I said, okay. And we went over and I went, oh my God. The sand over there was horrendous. And nonetheless, Walton County moved forward with trying to get the beach renourishment, and they can't pay for it by themselves. And ultimately, last year, this is all the way I remember it, is that the beachfront property owners said, I don't want to allow easements. The Corps of Engineers said, we got to have an easement from these people to actually do the work. And the beachfront property owners said, if that means I got a public beach, forget it. My house can fall in the ocean before I allow this to happen. And I heard somebody say that. They said, I got insurance. And so beach renourishment is, thank you, dead, gone. It's, forget it. And I'm number one. I think the county ought to spend every nickel they can on public beaches. I've gone to the county commission meetings and said, please spend this money, and I think that's great. But in the meantime, I think we need to craft this ordinance, and we're all here to do what we can to make the customary use ordinance, I think, the best it can be. And I'm hearing a lot of good ideas, and if we can gel that, that's great. That's it.
Okay, you still got time?
2 minutes, sir.
You got
Oh,
2
geez.
minutes. Okay, Mike, back to you.
Well, I don't know that this necessarily has to go in order, but I'll use one of my minutes just to tell you some of the good things that I heard from y'all as you were going through that I agree with. I did also notice the escalation in bad behavior, and I did notice the rise in the delivery service and the beach chair vending seemed to antagonize things at my local access when suddenly they were putting out chairs for people that weren't present, I think is what mostly alarmed people. So that definitely did have some effect in our area. I think the idea of the dry sand going to the dune of the vegetation, right? That's the way dry.
See, it's not me.
It's definitely the court. It's been defined historically. I think with regard to the chairs, there might be language that says something about privately owned and placed beach chairs might be more acceptable than when people have folks bring them in. I'm talking about a member of the public putting it on someone's private property along the beach, right? There might be a difference to those folks if it was just they carried it out themselves, or is this a chair that somebody was hired to go and put on? To me, would probably make a difference. So I think the language is something like privately owned and placed. I know the chair that I very seldom sit in, fits in my backpack. I carry it. It's so small, most people don't even realize it's a chair. With regard to the umbrella, I'm not sure what size. 10 does seem excessive. I don't know that I've seen a 10-foot umbrella. Privately owned and placed might also be another determinant on that. So if the person is carrying it themselves, I think that this speaks to responsibility. So when you brought that thing, you're responsible for it. You're there with it. You're watching it. But I think when we get things placed as a place marker or setting out there, we run into trouble, like when the storms pop up and there's nobody there to watch and take care of that and stop it from hurting somebody. So there may be something about that, privately owned in place. I would love to see a smoking ban. I don't think that's in our purview, but I also think that most people want to take in the fresh air, so I don't know what we can do on that. Absolutely, I'm a teacher and an educator in many ways, and education is going to have to be an important component of this. I don't know if it fits into the ordinance itself, but if we could put a line, something to that. I probably didn't share with y'all, but I serve on the St. Andrews State Park Advisory Committee regarding public use of the beach at that state park, and so I can tell you or corroborate what Celeste is saying, that they put a lot of attention to the use of the parks. In fact, I think we can look to the parks as examples of good stewardship. So when they have that cap, it's not because they're mean. And if I'm the guy that they say can't come in, I'm disappointed. But I know they're looking at the different species on the property, and they're saying, listen, if we have more people than this, then we can't protect this this plant or this animal or what maybe more people are more interested in is just enjoying the place if there's too many people. But they do those things, and for good reason. But those are just a quick list of the things as we went around that I absolutely agree with that came up. So I probably used one more of my minutes, but thank you, everybody. Yeah.
One or two more, but
No, that's good. I went around a third time. So use them up now.
This is it. This is my one or two now, and I'm done. I just, again, I was born here born in Defuniak Springs on the Circle. My family's been here about 200 years, since territorial days, and so I know the area, but I also know the beaches, and I maybe, David, I misunderstood you. I think you skewed me. I understand I've been here and watched all the developments, and I know it's more than the 800 or 900, and I know it's the 3,000 to 5,000 or how many. I've driven around and been around and had friends and been to parties in all of them, so I know how many homes there are in those type of communities. But there's also my point was making that there are thousands and thousands and thousands, which I don't think were really talked about earlier. To make that point of, like, I know the person that owns one of Q McGee's houses that's still standing lives in Paxton. So there's lots of upland owners that own property that would be affected by this customary use thing. So that being said, I love all this. I love, at least most of yours, the no smoking. No tents. I live on coastal Dune Lake, on Eastern Lake, but I face the water and I look out over the beach and the golf. And I can't tell you, this unattended, tents, umbrellas, anything. I have thousands of boogie boards that end up washing over into my yard. And it's scary when you have that sudden thunderstorm and to see those tents and umbrellas flying through the air that either could, if anyone's still on the beach, could impale them, or second, it goes into the coastal dune lakes. It causes, later on people are swimming or whatever, and maybe jumping down. It's dangerous, and the ocean is not good for animals. It's not good for people. I would say if you're not with your personal chair in an hour, then it could be picked up or something, that it needs to be monitored, because you never know often when a thunderstorm is going to come up. And they leave, and so that beach activities ordinance being enforced, one about is certainly picking it up at night. If I can tell you, it hasn't been until they've done a much better job the last year or two, but it's been mayhem down there. So that's there's lots of good examples here about the small chair, the no smoking. We do have a noise ordinance already, so that needs to perhaps be enforced. On my one side of the lake, I can tell you that some of the houses on the other side of the lake, or even on the beach, the outfall on the beach, I can hear music at my house sometimes. So again, this whole being polite and kind and keeping your music to yourself is good. I have probably used a chair on the beach maybe 3 times in my 60 plus years. I used to go down and I like to sit on the outfall where there's just a little dip. Maybe I actually either sit on the sand or I sit on my flip-flops, actually. And so, but if I want to sit in a chair, I will. If my mom's, maybe she's 80-something, wants to go down and sit for an hour, I'll row my boat down and we'll take a chair and sit for an hour. And so I think that's okay. And like you said on the tents, the way the sun is, people really ought to have a little more education about sun damage and melanoma and skin cancer, because those tents, I think you were talking about, Lisa, you don't just get the sun. We have our beautiful white quartz crystal sand and clear, and it reflects back up. So those tents are not protecting you. They're not protecting you. So that's that. Oh, and the education, incredible. Like I said last week, the $20 million that the TDC takes in, that a lot of that has to be in advertising. They need to advertise maybe some of that in the cities, besides just telling people to come here. They need to have some special advertisements. We get a new crowd every week, so we've got to educate them every week about the leash laws, whatever rules we have. And so I would think develop a podcast on these lease agreements, maybe where they have to watch it and hit the agree that it has to run for 2 or 3 minutes, like these are our beach activities do's and don'ts. And then you accept, and then you get approved to say that you have to watch something. That we support our local media, that some people do watch the news, especially if there's a hurricane coming or a thunderstorm, that they will watch the local news stations, the radio stations, the local newspapers, have some sort of campaign of the do's and don'ts of what good behavior is. And maybe even our TDC, hey, let's try to maybe get our TDC, instead of having a beer, booze, and butts in beds kind of campaign that we have, let's look at better activities off beach, more history, heritage tourism or something to get, instead of all this. We have a lot of focus on alcohol, and I think some of that bad behavior on the beach is from the alcohol, but that's just a bad behavior that's illegal anyway if you're publicly intoxicated, that the sheriff could handle without a complaint. So anyway, I think we've made some progress, and I do worry about Deer Lake State Park being mayhem with prominence coming in there. I see all the golf carts coming down, not only the street, but down the bike path and dumping people off there. And right now there is not a park ranger there. And so there's some real catching up I think we have to do to protect our state parks. Okay.
Next, Beth Clay. I was particularly taking note of Chuck's comments about why he chose where he chose Walton County versus other beaches. We too rented in Destin for 5 years, and then were fortunate enough to come down 30A and there's just no comparison. So I want to ask us too, do we want to turn Walton County into a Destin where you cannot go a half a mile in an hour during the summer? And do we want our beaches to look like that? And we made the comment about where would we be without ordinary and customary use. Well, we've not had it before. I mean, it's a new thing, and we're doing really well. When we advertise Walton County, we advertise the very uninhabited beaches, the sea oats, the dunes. I mean, that's what we advertise. That's what we say we are. We don't claim to be Panama City, and we don't claim to be Destin. So I think we should also try to keep in mind, do we want to preserve the unique county we have, the unique beaches, or do we want to just say, tourists, come on, come on, come on, no matter what? I think we certainly need to think about that as we go forward in what we say we can do. I don't think we want to attract the crowds and the type of activity that goes on the beaches in Destin and in Panama City. So I just ask us to think about that as we go through 4 and 5. We bought here because of the uniqueness of it and the less population and the less traffic and the beaches where you could go that weren't decked up 10 chairs behind you. As far as the prohibition of alcohol or in smoking, I think it's clearly within our purview. The state parks don't allow alcohol. And so clearly on private beaches, I think we have that right to say that in here. I think that's one thing we should look at in recognizing of private owners. There are many families today who have family members who are suffering from addiction and who are in recovery. And those families themselves do not drink on the beach because they feel their family members should not be exposed to that. So I think that's something that we should consider also. We talked about most of the properties being rented, and so that kind of made it open, but we do have particular neighborhoods where the private property owners don't rent. And so you don't have the commercial part of it. So I think that's something we should also consider. I think the county is doing a tremendous effort in trying to provide more public beaches. We all read about it and we see it happening. And I don't know that there's anything we can do about this, but it exists. We have several hotels that are a mile off the beach and up 30A, and they advertise and put in their customers' rooms, we will shuttle you to a private beach, a neighborhood access, when the public beach is less than 1/4 a mile away. So that's something that's happening now, and I don't know that we can do a thing about that, but you know, why would a hotel do that except to enhance their own business? But it doesn't seem right that a private neighborhood should be invaded by tourists that are shuttled there versus taking them to the public beach. And I'd kind of like somebody to talk about that after a while if you feel like it. It's something that I just don't think is the right thing to do. I disagree that there should not be a buffer at the toe of the dune. I think that states to the general public that you should not get right up on the sea oats or right on the dune. If you allow that, eventually, if you're walking your dog right along it, he's going to go up there, and children will be children. They're going to wander up too. So I do support some type of buffer at the toe of the dune. I think that's all. Thank you.
Chuck Schneider. I just want to say, and I'm just, really brief, I heard some really good things from the owners. We divide us up, owners and non, whatever, of activities that you would accept on the beach. I thought it was really good. I thoroughly believe that you can, as an owner, you can restrict the activities on the beach not to a really large degree, but if you don't want smoking on the beach, I say you can restrict that. If you don't want alcohol on the beach, that's a liability that you don't want to assume. There's no reason why you can't restrict that. I think that one thing that would be very good is to complete that list. Give a really good list of things that you don't want to see on the beach. You don't want to see nudity on the beach or things like this. You don't want to, if you don't want dogs running on the beach, or if you don't want dogs on the beach. That's something I think that you have the right as an owner to restrict. I don't want a dog on the beach because they do deposit things or leave things that, your family, could get involved with. One other thing that attracted us to this area was this 50-foot limitation, because that took us away from Destin and, in Panama City. Both Destin and Panama City, both of them have a problem, and it's a density problem. They just keep building and building and building. They build on both sides of that road in Destin. They have high-rises on one side and all the properties on the other side, and that causes problems. That's a density issue. You look at Panama City, there's certain areas that we drive along the coast, and it's dying. I mean, literally, it's dying because it's overbuilt. They can't control the construction, or I don't know what's going on over there, but that area is literally dying. It's not a live, vibrant area, and they're finding that out when they pass the ordinance that you can't have booze on the beach, during spring break, because they figured out that they have to maintain a family environment, and they don't want those kids anymore. They want them to go elsewhere. One thing that you did say that really bothers me, that made me think, is what happens on the other side of 98? What if they do start putting high-rise motels and hotels over there? What does that do to our beach? That just little incident that you just said, I'll be honest with you, scares me. I don't think it's something that we can resolve with customary use, but that is something that I think in the future will have to be looked at. But I still agree that I think this agreement, this ordinance is necessary. I think it's an important factor to keep our area healthy, but I do think that it's not perfect. I do think that the private owners need to maybe have a little more input as to what they feel is proper on their property. But I do think that the public and the people that do need to have that access. One thing that really bothered me, and I mentioned it to a friend as we were sitting having a cup of coffee in Seaside, is that during the high season I was walking down the beach, and I get to Seaside, and there's this sign here, private beach, restricted. They were putting out posts, and I found that offensive. Maybe I found it offensive because I wasn't renting in Seaside. I had before, because I've rented in Seaside in watercolor. But I found it personally offensive in the idea that they would put that up as a barrier. I can walk on the wet sand and things like that, but it just wasn't the nature of the area that I wanted to be involved with. And that took Seaside a notch down to me. And, people want to come here and rent. I recommend that they go someplace else rather than Seaside, because it was too restrictive. It was just offensive. But anyway, I'm rambling, so thanks.
I don't really, I think I said most of what I want to say. I mean, I've got other notes about things like a whereas. Sort of like what David did. I was like, whereas customary use is recognized and protected. However, the county also recognizes the private property rights of deeded ownership of land, including the dry sand beach. As such, this ordinance is intended to balance those opposing rights. So it's that could be like the net of the whole thing to me. But I have mixed emotions, because I think most of you can probably tell that I'm not unwilling to share the beach in a limited capacity. I don't want certain things done on my property, and most of you seem to understand what those are and why. At the same time, I have a reluctance about declaring customary use, not because of what we may now understand well, but because of the interpretation by the public. A lot of times, I saw an awful lot during various times during these discussions where people talked about entitled beachfront owners, that we didn't want to share, we were just bad people. And I sort of see the other side of that too is, yes, there are some beachfront owners that truly don't want to share. Period, end of conversation. They'd like to put a fence and nobody goes there. But there's a lot of entitled people out in the world too that want what somebody else has and thinks they have just as much right to it. I can't tell you the times that I've had people use my walkover to, get from the street to the beach, that I've had them use my water hose to rinse off because they've been on the beach and they come up and decide they can just use my water. Our rental house is really bad there because it's a flat area. My personal residence, you have to come up a long walkover to get to me because I'm up at a 40-foot elevation. But my rental house, I had to put cameras because people were constantly walking from 30A to the flat beach. And they would go under my house, up the stairs, across the platform, down the stairs. We have an outdoor shower for our guests, our renters to rinse off, and they'd use the shower. They'd use our water hoses. If they found chairs or beach toys, if you will, that we have in a little enclosed area, they'd take them and use them, leave them on the beach, stuff like that. And you just sit there and you're just appalled at the fact that they think that just because I had one of them tell me, well, this is a rental house. Nobody owns it. I said, I'm like, what? Anyway, so you really do get some bizarre things. And that's why the idea of customary use, if it's not real clearly defined, like several of you have mentioned, with the education and the understandings that go with it, is a scary thing, for some of the beachfront owners. But I don't really have anything else of major consequence to add unless something new comes up. Go ahead, Lisa.
Well, like Lisa said, her private property is being abused at times. How can we, in this ordinance, reword it to protect the private owners? That's what we need to come up with. Yes, we need to define what you can and cannot do on the beach, but let's define it to where the homeowners are happy. And I don't know how we do that, but that's what I need you guys to think about.
Okay. The concept of carrying capacity at the state parks is very interesting to me. That smart people spend a lot of time figuring out a number based on presumably careful research. I think that our community is equally as special, and it's equally as rare in this day and age. And I think that it would be worth us spending some time figuring that out. Now, it may not be as simple as having a gate at the 331 bridge and at the either end of 98 and saying, sorry, you guys just radioed, we're full. But that would be a challenge for us to think about, because if we don't protect it, we're going to lose it. I don't think, as a percentage, I don't think the majority of the people that come here spend as much time thinking about it as we have over the past couple weeks. That's one reason why I believe that adopting the customary use ordinance without knowing what the answer, and I'll just pick one question, the answer to the question of what are we going to do about hotels dropping people off? We don't know the answer to that question yet, and yet we just adopted an ordinance that made it possible for them to do that. and it's coming around here April 1st. We're going to find out how many hotels have figured that out. I think that the proper challenge, I think one of the things that I don't want to sound cheesy, but one of the things that makes the United States different than many, many other countries is that we rely on our courts to sort things out for us. And I think the idea of having this very complex question challenged and the court running it through and people having to make their arguments and the system and whatever level it has to be sorted out, helping us answer this question, I think that's a very reasonable thing to expect of our local government. So, I think it's unfortunate that it burns up so much time and money, but I think that is perhaps the best way to get to the bottom end of this list. So, thank you.
Well, I like the idea of carrying capacity, and I think Walton County can work on carrying capacity, and that is in the density of the developments. I mean, we see it all the time, and I don't go around complaining about what the people are doing on their private property, in developments, unless they affect our public lands. But, when you have a dense property, you're putting more people on the beach, and that's not that's not what we're doing here, customary use. That's something the county needs to deal with. That's their carrying capacity, and anyway. I just want to go back to, I believe there needs to be the 15-foot buffer, but I believe it may be better being in the activities ordinance versus this. Maybe I'm wrong. I just want to throw that out and consider it. And I think, there is some consensus here about how we can come to possibly an ordinance that the group can recommend, maybe not, I don't know, but I see a lot more of this gelling in a lot of ideas now, so you made me think of something though over there, Mike, that you're saying, I don't want to go to Destin. Last year I had an incident when all this was going on with the people being run off the beach and all the no trespassing signs. I'm sitting up there at the nail place having my toenails done. I just love having that done. And the lady next to me was staying down at the retreat, and we were talking about things, and she goes, well, I used to stay we came to Destin, but now we're down here. And I said, oh, isn't it so much nicer in, South Walton, being all proud. And she says, well, there's all these no trespassing signs down there, and it really kind of just makes me not feel welcome at all. So.
Thank you. Okay. Let me give you my views on this. I think we need to restrict ourselves. Thank you, Ray. We need to restrict ourselves to the customary use ordinances that we've been presented here. And there are many kinds of things in Walton County that need to be addressed. I will agree. And I'm sure we could have all kind of sessions on that. Someone had mentioned pumping in the beaches, and we did that on the 4 miles on the west end of Walton County. Originally, it got challenged in court. The beachfront owners said, no, you've taken away my exclusive right. This was a taking. Went all the way to the Florida Supreme Court. Florida Supreme Court said, no, it wasn't a taking. They got Scalia, Justice Scalia, to take it up to the Supreme Court. And Justice Scalia has always had a theory that us ignorant state court judges and corrupt state court judges could take private property illegally. So he took the case up to the Supreme Court, and he went on for 40 pages about the theory of judicial taking. But he said, but in this case, it wasn't a judicial taking. And the court case was an 8-zip opinion against the property owners who complained that it was a taking. Stevens recused himself because he owned Atlantic front property. Any rate, the point being, I agree with the gentleman who came in and said that would be the solution. But that has been precluded because beachfront property owners who don't want this to occur are not giving the Corps of Engineers the permits to come in and do the work. So that's a non-issue now. But at any rate, back to this. You know, the whereases and whereases. This normally in a statute, this gives you the possibility to discern intent of the actual body of the statute. So, you know, you can get into that, or all the whereases, but when you get past the whereases, then you get down to work. And the couple of comments that I would have is in the section 2 of the paragraph 1, and they say that the purpose is to protect. I would insert the word as well as recognize and protect. Incidentally, I think...
I'm not sure where you are, Judge. Excuse me. Can you...
All right.
Okay.
Section 2, paragraph 1.
Section 2, paragraph 1.
Okay.
Okay, where it says here, the purpose is hereby, for recreational purposes, is hereby protected.
Okay.
I think recognize and protect, because I think that this is what the county is doing here. They're not creating new legislation. They're recognizing customary use, and I think it just needs to be clear there. Incidentally, I think this customary use ordinance needs to go forward, but it needs to go forward only with the county recognizing some serious recommendations that this body should make to it, okay? And that's step 2, okay? Let's get on with that. I think also we must understand that customary use, when you really boil it down, is only talking about, it's only affecting the private property owners. The other when it talks about public beaches, non-private beaches, that should be covered by the beach activities ordinance. It probably already is. All of the things that should or shouldn't occur there should be covered. And so I would recommend, when we come down to 4, I think we ought to pare it down to just the bare essentials of what the public is entitled to on private property. Walking, jogging, and I wrote these down from you. Walking, jogging, sitting on the sand, sunbathing, fishing. I don't know, sand castles, I guess so. Okay. Let's see what else they say. Sitting, I don't know about beach. I wouldn't get into that. Beach chairs and beach towels and blankets and umbrellas and how much diameter. But, you know, picnicking, okay. Again, I would avoid this playing ordinary games because that's too vague to me. Okay? And similar recreational activities has to go. Then I would add into the same paragraph activities on non-public areas of the beaches are covered by the beach activities ordinance. Just end it right there. That's it. You know, and in law, if you don't want to get into a situation of pronouncing everything that cannot be done, you can't create a universal negative. You know, you don't want to get into pronouncing everything that can't be done or can be done. But in this ordinance, if we can pare down in paragraph 4 about the very minimal things that are allowed in customary use, and I would include in the customary use, yeah, I don't want to get into negatives too much, but I agree that there should be no tobacco or alcohol use on private property. Now, I don't know what the beach activities ordinance does with it, but I would, you can't hardly stop alcohol on the beaches, you know. I don't know how you can stop it on the other, but I think you can. I think that's one specific prohibition that you could put in about private property owners. I think that's a very valid prohibition, you know, that that this prohibits any alcohol or tobacco use. And I would do tobacco, you know, in general. You know, everybody's going to do something because now they're smoking these damn electric cigarettes or whatever, you know. But at any rate, you know, but if you get into trying to do that. And then number 5, I'm on a roll. Hold off, okay. The following recreational activities are prohibited for members of the public on the dry sand area that are owned by private property entities. Erections of tents is defined in the beach. No. That's the whole thing should go. It doesn't make any sense. You know, it's already. It's because in 4 we've said these are the only thing you can do. These are the only things you can do on private property. Now, the other things that you're restricted in doing or allowed to do are covered in your beach activities ordinance, but that's only on non-private property. So you can really see that the beach activities ordinance boils itself down to activities on private property. You know, when it comes, or it should, in my case. Promulgation. Everybody, like I said to y'all in one of the first meetings, is that no statute is valid or constitutional unless it's properly promulgated. So the public is going to have to, we're going to have to feel, I think we need to recommend here that the commissioners, one of the recommendations I would make, that it be properly promulgated not only to the local residents but to our visitors. Now, I don't know whether y'all want to get into how to do that because there'd be a jillion discussions. I agree TDC's got all kind of money to do that. Maybe we want to say that this customary use should be properly promulgated, and the cost of that shall be borne by TDC. And maybe let TDC be the functionary in doing it. The cost and the promulgation of this shall be done by TDC. You may want to think about that, okay? But I think it's I think it's an important thing to do. You know, there's some other areas that I have thought about. We live down at Easter Lake, Brenda and I do, and there's an old customary walk over there, and somebody brought this subject up last time. I think it was you, and they talk about. Let's assume for a moment you've got a beach access, and then on either side of it, you do have private property. Now, I don't know whether it is now, but when people go out those beach accesses, they don't disperse more than 200 yards either way. And it's just the nature of things. I've been here 20 years, and Brenda's been here all her life, and I think she would agree with this, is it's just the nature of things. They're not going to do it. Now, if I were a private property owner on either side of those things, that may upset me. But I don't know how to cure that right now. You know, I don't know how to cure that. If y'all got, you know, it would be upsetting just because of the increased density.
You need a carrying capacity.
I need a carrying capacity.
A carrying capacity.
But actually, if you sit and think about it, if this is private property and it goes down to the water's edge, no matter how dense it is, it would that activities there will still be subject to these limitations. Okay, so you can't have people setting up tents and doing the only thing they can do if you choose to be that close to the walkover, you don't want to walk another 100 yards down the beach where you can be private, you know, then you're going to be subject to no tobacco, no alcohol, no, you know, these things here.
No tents and stuff, it'll help.
Mr. Chairman, since we did X the prohibited things, should we put on number 4 only the following recreational activities?
Right.
Okay.
Yeah.
Yeah, I think
We
it
got-
need to be listed in detail.
Right, you got to be very, very specific. Now, what I do like to do tonight, I think you made great progress here, and I appreciate so much that this committee has been so responsible and worked so hard at trying to come to some conclusions here, because it's difficult, and the public as well. I think I would like to entertain a motion that either the customary use ordinance not go forward, be killed, or that it go forward but subject to, but containing the recommendations that this committee will make on it. And then for our last meeting, it seems to me, and I don't know when that'll be, we'll have to talk about that in a little bit, but for our last meeting, that let's have everybody come back in and say, okay, let's boil it down, you know, get down to the real nitty gritty of what customary use means, and that it applies, you know, only to the private property. Well, it says that it applies to all of the beaches. But I think the beach activity ordinance should apply to the non-private beaches, you know, and just simply refer in section 4 that all other activities on non-private beaches are subject to the rules and restrictions of the beach activities ordinance. And that's going to be, I'm sure that's going to be revised. But I understand it's already 20-something pages. God, the Constitution isn't that long. You know, I mean.
We're talking about beach tents and toys.
Yeah.
Mr.
and
Chairman.
I mean, you know, they get to talking about all kind of other things. And look at the hoorah we can get over the Constitution. But, yeah, good.
Mr. Chairman, would you be opposed to a motion that said that we would adopt the changes as proposed by you and have legal counsel have it typed up and everything for approval by our next meeting?
I would not be opposed to it.
I'll
I
second
would
that.
do.
We had
I
some
make-
discussion about
there's-
this.
I make the motion.
There's a
I'll
motion
second.
and a
For
second.
discussion now?
Yeah.
Discussion on that motion.
Yeah, I still would like for all of us to have reserved the opportunity to share our recommendations personally, like Governor Huckabee already did. He's not here tonight, and how each of us, I think we're hoping to do.
But without doing it as a committee?
I'm not saying necessarily without, just making sure that we
In
have.
addition to doing it.
It would have
as
to
a
be in
committee,
addition to.
To be able to.
But if we were going to entertain that motion, I would like to address exactly what the motion was again. I'm not sure I heard clearly what the motion was, so.
If I might, please. The other thing, the reason that I did not include picnicking in my allowed activities was not because I have an aversion to people eating on the beach, but I'm concerned that if picnicking is in there, that will get used as a way to bring a big group of people to do. So, okay, well, that's the only one you said that I thought, I don't know, I'm a little kind of uncomfortable there.
Well, here are the activities. Let me be very specific.
Perfect, thank you.
Would that be okay?
Yes, sir, thank you.
Please.
Activities that I am suggesting that the only activities that are allowed on private property beaches is defined in the ordinance. Otherwise, will be walking, jogging, sitting on the sand, sunbathing, fishing, building sandcastles,
I have a question.
that's it.
Have it sitting on the sand, all those other.
I have a
Oh,
question.
we did, okay.
As you're suggesting that, are you taking consideration when the beach is not present, when the beach is not 15 feet, or when the water is lapping against a seawall? How will I still be permitted to carry my surfboard, to stop, to leave a second board? If there's only 3 feet, I might still want to do that. So how do we preserve that ability when the beach is less than 15 feet? Or
Where would you want to leave it, Mike?
yeah, I would generally, if there's a little bit of dry sand, I would set it there. I frequently carry 2 boards or more down with me to change up when the conditions change or whatever. But I'm just thinking ahead. If you went through with this, that would be restricted.
That doesn't do with uses. That does with defining the beach area.
I'm just saying, I wasn't going to quibble about no surfing on this because I thought we're talking about the dry sand, but it's possible that 15-foot area could also be, it could be smaller than that, and then where do I set something if I'm going to?
That's what I'm telling you, that's defining the beaches, okay? That's not defining the activities. Okay?
Well, we're defining what we can do on it. So I guess I would can set a piece of sporting equipment temporarily on the beach, or there might be some language to that effect, so I can do that?
Well, and remember, Mike, the whole purpose behind the 15-foot buffer is really for emergency vehicles and stuff. It's not really to keep people from walking up there. For instance, turtle watch people, I guarantee you are going to walk up there because that's how they spot the turtles.
I will go with swimming and surfing off the beach. How about that?
Okay.
All right.
Yeah, I like that.
Swimming and surfing.
Okay.
Everybody good with
Add
surfing?
swimming and surfing.
Because you
Right.
can't surf without a surfboard. The last I saw it.
Right.
I've tried it. I've tried to get Jeeps to swim. I've tried to get them to fly. The damn things don't do either. But at any rate, I'm sorry. But those are the things that I'm recommending that be the limited activities of customary use on private properties. All other activities on the beaches of South Walton should be covered by the beach activities ordinance. So even when you get to these congested areas, I mean, theoretically, I don't know whether it ever happened, but like at our place, if you come out and there are a lot of people there. But theoretically, if it really got bad, then the TDC or whoever's going to patrol this sort of stuff would come down and say, no, you can't be smoking out here. You can't be. Didn't we add in no
Yes, sir.
smoking?
You said no tobacco and
No
no
tobacco
alcohol
and no
use.
smoking. Okay. I think we have to add that in.
Right, no tobacco or
No
alcohol.
tobacco or alcohol. And,
Right.
well, I started to
I
put
think
drugs.
drugs are already, drugs are already in the beach.
What I was going to ask, thanks. What I wrote up here are the activities that are in the ordinance right now. And since there's a lot of different ones flying around, just to make sure that we all are on the same page when we leave with the ones that I'm hearing a recommendation on, and if Judge, if you would just repeat them, this is what's in the ordinance as currently written. And you'll see that there's 10 activities that are considered by the BCC to be customary use. Sitting on the sand has 3 subset activities: on a beach, or on a chair, on a towel, on a blanket.
He omitted that.
Okay, what's that?
The judge omitted that.
Yeah.
Okay, so
Sitting in, on the sand was what he said.
yeah, that's what I was wondering. Is that sitting on the sand, but nothing
You're
underneath?
not going to have the chair or the.
I'm not
beach
worried
chair?
about it.
I'm just trying to make sure we all have the same understanding of what's being proposed right now. And I've got, and I didn't get them all yet. Walking, jogging,
Jogging,
Sand and whatever.
sitting on the sand,
So that one underneath it.
okay?
It's more general.
sunbathing, fishing,
Okay.
building sandcastles, but no use of tobacco or alcohol is permitted.
Well,
Could we expand the sand castles to sand creations?
Sand structures or.
Yeah, whatever,
Yeah,
sand creation.
Because some little
Sure.
kid's gonna wanna build a turtle instead of a sand castle, and I certainly don't have a problem with that.
but now, you mentioned no, so if I go down there and I put a towel on the beach, is that going to be a problem for
Now,
somebody?
you're sitting on the beach.
I think it expands that.
Yeah,
So it's not saying you
Well,
can't have a towel.
I'm just saying, some of these,
You're
there's been
sitting
some.
on the beach.
I think that's good.
It says I think, I
Sitting on the sand means sitting on the sand, is what it would mean to me, not that I get to sit on a towel on the sand. Or in a chair on the
and I
sand.
think, I just think there needs to be some language so that somebody, people don't like to sit on the sand, and I'm sorry but somebody will say, you're not on the sand, you're on a towel.
Let me give you an example about interpretation of law. Okay? In Louisiana, in 1954, we wrote one of the best criminal codes. My professor, Leon Hubert, helped write it. In Louisiana, it was about that thick. And it talked about theft. And it said, theft is the taking of anything of value from another. Beautiful. Covered everything you could imagine. Taking a 747 airplane or whatever. Some DA out in western Louisiana lost a case where some crawfish were stolen from some guy. So he goes to the legislature to get a special theft of crawfish. From there on, it went. Man, theft of this, theft of that, it's silly. The point that I'm making is, the simpler you can keep it as a code, as a compact, as a concept, the better off you're going to be, in my opinion. But, you can say sitting on the sand with white towels, red towels, blue towels, or sitting on the sand with whatever.
Well, I just don't want the sheriff, somebody to come down there with a towel because they're going to swim.
Well, I
and then
know
have the
that-
sheriff be called out there because that lady's got a towel out there.
I know, and you
know?
got to know what size the towel is. Is it a really towel
Well,
size, or is it a half a set towel, or Any rate, that's the only point that I make. That what you really want to do when you're recommending legislation, we're not creating the legislation. We're going to be recommending it to these people. At least I'm recommending that we recommend that the ordinance go forward on April the 1st, but with the inclusion of the recommendations that we're making here. Now, we may have some other recommendations that we want to take up, but we're running out of time tonight.
Yeah, okay, can I just make one recommendation then in reference to that? Instead of saying sitting on the sand, sitting on the beach, and I think you had said that previously.
That would make it more clear.
That way, it's kind of like, well, okay, well, I'm sitting on the beach, but I got a towel versus, well, you're not on the
Or your
sand. You're not on the sand,
Yeah.
so.
And what I was going to say, and the judges have seen this before, if you have some history now that these are permitted uses, if these three are eliminated, there's going to be an interpretation that they were eliminated for a purpose, and that purpose may very well be restricting strictly to heinies on the sand, if you will. That's it. But if you change it to beach, you might accomplish both goals.
Sounds good.
That sounds good.
Does that make sense to you, Judge?
Making sense.
The part about surfing equipment didn't make it onto the list, just so you're.
Oh, we haven't gotten that.
And I think, it does sound a little ridiculous when we're talking about the dry sand area. I understand that, and most people don't, understand what it is we're doing. But it could be temporary placement of surfing. You might say surfing, paddleboarding, swim equipment. So that would limit it. So you wouldn't have. You're not allowing boats. You're not allowing jet skis, which are illegal here, right?
I think
But you're making it clear that a person can
swimming or
put their
surfing.
goggles down while they go to rinse off in the ocean or something
I
like
think
that.
when you say you're surfing off the beach, that pretends that you've got equipment.
I have what he wrote. I have the motion and what he proposed, if you'd like for me to read it. Okay. As proposed by the chair, only the following recreational activities are permitted for members of the public on the dry sand areas of the beach that are owned by private entities: walking, jogging, sitting on the beach, swimming and surfing in the water, sunbathing, fishing, building sand creations, period. And no tobacco, you don't have, not and, no tobacco or alcohol may be used on private property. Activities on non-public areas of the beach are covered by beach activities ordinance.
Sounds right. There's a motion to that effect.
Still second.
And there's a second. Any further discussion? All in favor of, does this motion include stating that the ordinance should go forward with this reservation?
Yes, I think that was your motion, so yeah. I mean, that was your intent.
Does it also go forward with our personal
It should go forward on
statements?
April the 1st, but with these modifications.
Okay, the chair's motion was that the ordinance would go forward on April 1st only with the restrictions that are in his motion.
And that you would entertain a motion to accept customary use subject to specifics.
To the restrictions,
But we don't want to say specifically in there, no tents or umbrellas.
No, anything else is prohibited.
Okay,
Everything else is
that's going to be
prohibited.
an education.
Oh, you're right. Yeah.
We have the right as a committee to ask, David brought up a good point, this is going so fast. Do we have the right to ask them, there's a lot that needs to be changed in this ordinance, there's a lot to be hammered out. Do we have the right to ask them to hold off?
Oh, sure.
Don't
Yeah,
put
you
it
have.
into effect April 1st. Give us 6 months or a year. I think you mentioned 2017. There's just too much to
Well,
change.
you have a right to do that, but, you can make a separate motion, a different motion after we see what this one comes to, okay? We have a motion on the floor. We have a second. Further discussion on it.
Mr. Chairman, I'm, Section 2, Paragraph 1, other than changing the words to "are hereby recognized and protected" at the end of the first sentence. As I tried to make clear the whole way through this process, the statement, except as stated in Paragraph 3, no individual or entity shall impede or interfere with the right of the public at large, etc. That is a very hard to understand. There's no definition of what impede or interfere means. there's only, you mentioned a second ago that the whereas clauses can be used in part to help interpret it. There's only one of the whereas clauses recognizes rights of private property owners. So I have a concern and will be unable to support the motion as made because there's still an insufficient description of what the rights of private property owners are.
Okay. All right, the motion is before. Any other discussion on the motion?
Sid, may I ask a question of Sid,
Sure.
please? If customary use is struck down by the court, what happens to this ordinance?
That's a good question.
It could be just portions of it.
There's a lot of different ways I guess it could be struck down. I guess like Rosemary Beach and some others have argued that the county doesn't have the authority to enact any ordinance. So if the judge ruled in their favor on that argument, then it would be ineffective.
It would disappear.
Yeah.
Okay.
There could be all kind of, it could be struck down in whole or in part.
Right.
Okay, because all of these ordinances have what we call a severability clause in there, which says that part of it is struck down. It doesn't mean that the whole of it is.
So if this passes the way it is, does that mean we can't then still add in, for instance, your suggestion of this being properly promulgated and funded by the TDC and changing some whereases to include private property owners?
You can add all of that in.
So we can add more things next week then. So
Yeah.
this is really
Yeah,
addressing
this is-
paragraph 4.
Right.
More
This
than
is
anything
This is
else.
what's happening right now.
Okay.
But it's also saying that the ordinance should go forward, but with these changes,
Right,
okay?
with these required and
Right.
maybe some others that we
And
could
maybe-
also establish next time.
That's correct. We still have another opportunity for additional recommendations to the board. Any further discussion on this?
Yeah, I like the idea that we would move forward here, but I feel uncomfortable voting on something I'm not, I don't see it in the language in front of me, and we all know that it matters. I hate to be that guy again, but I'm a little confused on the exact language of it. I think you clarified the part for me, but there's still a couple other pieces.
I'm sorry to interject, but I think that Ms. Clay's motion was for me to draft the language and bring it back to you guys at the next meeting.
That's a different motion in my,
Okay.
the way
Yeah,
I'm hearing it.
Right.
Yeah, thank you.
We may, and at next week, we may have some other things we want to include, and be thinking about that, you know? Okay? But this is just for her to draft language.
Okay, I didn't hear that part at all. I'm sorry.
And don't let me speak for you, but that's what I heard at the beginning.
That was that was
Okay.
my
Right.
motion, and bring it back to us.
Okay, so we're just voting on these do's and don'ts.
On number 4,
Okay.
right, number 4,
Okay, so that's what this motion is.
right.
Yeah.
Well, actually,
It's for her to write up what we
and
just-
we X'd out number 5 because we had.
Right.
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 We X'd out number
So
5
those changes
totally.
will be made and.
Yeah.
That was my
Okay,
motion.
that's the motion, that those changes be made on this ordinance. All in favor?
Aye.
Any opposed?
Nay.
Okay, okay.
Point of question for timing, next Monday is the 20th, which is it's either state or national, but it's the 20th.
It's a state. May I ask a quick question before we get to scheduling? May I ask a quick question, Mr. Chair? And it actually goes to the issue that David had raised, and it's on the substantive. So I wanted to, the issue that David raises about that impede language in Section 2, Paragraph 1, about impede or interfere. Given what you all have just decided about the permissive activities on private land based on customary use, David, does it solve your concern if in one, leave it the way it is, except, and I'm reading now toward the very end, to utilize the dry sand areas of the beach that are owned by private entities for, instead of recreational purposes, make it for recreational activities permitted by paragraph 4. And what that would do, if it was changed, changing the word purposes to activities permitted by paragraph 4.
You'd be further restricting it.
What that would do is paragraph 4, those activities y'all just decided on, would modify, impede, or interfere. And I'm not asking you to decide on it, I just wanted to throw it out there before we went to logistics, maybe to think about, okay?
That's positive movement.
So, recreational purposes in paragraph.
I agree, that makes sense, to do that, and that's one of the things.
It does.
Is it possible to have this emailed out to us before the meeting so we can kind of look at it and think about it,
Yes.
Okay.
And
Is it possible for Sydney to take, based on some of the whereases we went through and comments, is it possible for her to maybe propose some changes to whereases? For instance, the very first one where it really doesn't mention the private property owners at all, even though it mentions, the public at large, the residents and the visitors, but it sort of leaves out the private property owners. Can she do some things like that, maybe suggested changes
Sydney
based
can
on what
certainly
she's
come
heard?
back and suggest language to clean up
Yeah.
this whole thing, the whole ordinance. Well, I mean, there's some,
Homework, Sydney.
Pursuant.
but there's some, and we want to hear from her because we may have some pitfalls in here with the language that she can pick up on.
Right, so what I can do is make all the changes in Ms. Clay's motion, and then I guess as far as the whereas clauses and even the restrictive language that Rob mentioned, I'll just include those, but I'll make sure that it's draft.
Parenthetical.
Okay.
And I think you could probably go ahead and add the properly promulgated, not only to residents, but to tourists, and the cost shall be funded by TDC since.
Oh, that's for that one.
Yeah.
Okay, the ordinance should be properly promulgated, not only to residents, but to tourists, and the cost should be funded by the TDC.
Okay.
That was our suggestion.
Yeah, and maybe not only the cost, but the obligation to do so should be something to that effect.
Responsibility.
Should be TDC's, and they should pay for it. We don't want to get into trying to tell them how to do it. You get into that, then you leave out something, you say, well, they should have done it, if they didn't say do it this way, then it's not permitted. Anyway,
Mr. Chairman, if we submit all these changes, if we send personal changes, we redraft this with all this of our good suggestions.
right,
But we get it to them by March 1st is our goal.
right.
Do they have enough time before their March 14th meeting to really study this? Or?
I hope so.
Well, and I guess to address that, so if you guys have changes to me by March the 1st, do I have this on? I'm sorry. Okay. So the BCC has their first meeting in March on the 14th, I think. So I would give the proposed recommendations to the BCC at that time, and then the BCC could vote to advertise and hold a public hearing at their second meeting in March. So they would have time to make these changes before the ordinance becomes effective in April. It only requires one public hearing, and we'd have plenty of time to do that.
And there's no way we can
And the BCC,
send that?
that's a possibility. But the BCC, if you guys get everything to me by the beginning of March, they'll have a whole month, almost a whole month to consider it before they would adopt any changes.
well, I don't know why, if is it possible to get all these recommendations to the county by maybe, well, I guess I'm just looking at my calendar, by the end of next week? Is it possible to come to some conclusions at the if we can have a meeting next Monday. I don't know, it's a holiday, but we had a meeting on the other holiday, so if we could,
That's true.
yeah, so if we could wrap it up next Monday and then everyone get their recommendations, I think everyone's pretty much knows what they want. Move up that date from March 1st, to next week. I mean, I don't know why it couldn't move a little bit faster.
Well, we're going to have at least one more meeting for
Right.
them to come back with the cleaned up language and everything where
Right.
we can have a final motion and a.
Right,
you know,
and so I don't see why we couldn't do that. Yeah.
They've been listening
On the
to us.
20th.
Something that just occurred to me is that the beach activities ordinance allows 6x6 tents. I'm not sure I'm comfortable dropping paragraph 5 altogether.
Well, that's not going to apply to private property.
Well, I know, but I'm afraid that if we don't specifically say, because somewhere it said activities on non-private, that's true, but I'm just afraid that's going to be a point of contention.
Well, it's not going to affect private property. Now, you may want to go to the beach activities ordinance and get that changed.
Well, that's already been done, it's 6x6.
I kind of agree with what Lisa's saying, that why can't we just leave in 5 that prohibits tents? And that,
Yeah, I think that goes back to making it not as easy to defend in court when you get specific like that. Was that your reservation on that kind of thing?
I think you better go just take that up with the beach activities ordinance. See if you want to go back and.
The TDC's my biggest, code enforcement is going to have to, they're going to get the onus of enforcement.
Yeah,
You
I
get
know.
the bank on it. And I'm just concerned that the overhead structure idea is, whether that's tents, umbrellas, whatever, that's going to pose a problem. But we can talk about that.
doesn't have to do
I know this is getting into some.
Doesn't have to do with customary use.
Yeah, and I know this goes into what promulgation, I'm sure that's a new word to me, but getting advertising out is that maybe one of the things the TDC can do is create some new maps that say, this beach is private.
That's up to TDC.
Okay, but I'm just making that suggestion because I see Lisa's point.
You're going to pay for it and you're going to do it.
Yeah.
Okay, don't tell them how to do it if they're not paying for it.
New maps.
But let's get back to the critical issue of when are we going to meet next?
Well,
and hopefully,
I would like to meet again next Monday at 4:00 if that works for anybody.
That's a holiday. I don't know.
So y'all can't do that? Well, I don't know.
What about the next Friday then? Could you meet the next Friday?
Okay. For a Monday meeting, we probably need to make sure staff is available.
Yeah.
What about Friday? What about that Friday after the Monday then?
That would be, so are you proposing February the 24th?
Yes.
That would be acceptable.
February.
That's good.
During the day or in the evening, whichever you prefer.
What about that afternoon in case people had Friday plans? I don't know.
All right,
But
February the 24th.
what about 4:00 on Friday then? Or 30, or
you've got school.
it all?
Early is hard for me.
Monday's out, though. Is that what I heard?
Well, I'm good. I'm good with Monday. I'm good with Friday or Saturday. Can you do Saturday, Lisa?
I can't.
Can we meet at Mike Huckabee's house on Monday on the regular time?
He's out of
He offered
the
it.
country. He's out of the country, I think is his problem.
Okay, let's get a consensus on a date then.
We have an offer from the public.
Well, the 24th works for me.
I don't know if this would be cutting it too close for you guys, but I mean the 27th, February the 27th, which is a Monday.
I'm okay with that.
27th would be.
27.
I'm okay.
All right, well, that works.
I'm okay with
27.
27.
I could do the 27th.
27th is,
Okay.
shall we have a motion to this effect?
I'll make the motion that we meet February 27th at 4:00.
Second that.
Are we going to do 4 to 8 again?
God, let's hope not.
Let's just say 4. We'll start at 4.
Right?
Oh, yeah, we
Should
know.
we set it, advertise 4 to 8?
Yeah.
Whenever we advertise, we just say it's beginning at 4.
Oh, okay.
So you guys set the parameters of when it would end.
Gotcha.
February 28th, 4 p.m.
No, February 27th.
27th.
27th, Monday the 27th at 4:00.
Mr. Chairman,
Uh-huh.
would we be able to, and I know this is a biggie, would we be able to scratch the word all from the third whereas, the fifth whereas, and the sixth whereas.
What effect would that do?
Yeah.
I'm looking at it, and I'm thinking, if you take all out, you're just,
You're opening
all the
the
beaches
door.
anyway.
You're opening the door.
beaches says the
then-
beaches.
You're really opening.
Then somebody's gonna say, well, it didn't mean my beach.
Yeah, I would leave in all.
Yeah.
That's what bothers me. You're laying the public onto private beaches.
That's what customary use is.
That's what it's all about.
That's the ordinance.
Yeah.
I don't feel this needs to be.
Well, I don't think it's inviting them on in any way. It's just, yeah, I don't see any benefit in doing that, Lacey. I really don't see any benefit in distracting all.
Yeah, I think.
I mean,
yeah,
if you
wouldn't
just
mind.
say
That sounds good to me.
beaches, if you said the beaches, or you're driving at the same.
I feel like
Smoking or consumption of
they're
alcohol.
making a
Smoking broader
really
than
strong
tobacco.
statement.
Yeah, they're making the statement
Smoking is
there,
broader
that
than
their
tobacco.
evidence
That would
showed
include the
them
vaping, and that
that
would
all of
include
the
marijuana, that would
beaches were
include,
subject to.
pipes.
Now, that's gonna
I
get
would say
challenged
smoking
in
and
court.
consumption of alcohol.
You can bet.
No.
There are gonna be two things that are gonna get challenged in court. The main thing, and this is not our business, okay, but what's gonna get challenged is interruption. I interrupted this. Well, I'm sure that's gonna come up. And what are the beaches, may get challenged, whether or not the proof was to all of the beaches, whether or not there was sufficient proof, beach by beach, that's all gonna get challenged in court, but that's something we can't correct or avoid. We're not gonna avoid that. It's good. Let's be practical, folks. I think this committee has done a great job in getting very sensible with the language about the customary use here, and trying to tell the county, be sensible about this ordinance and do what you're going to do. But it's still going to be challenged because, as Lisa has said, there's some people who just philosophically don't agree with this. They just say, this is my property and I don't want anybody on it at any time. So it's going to get challenged in court, but we can't help that one way or another. And that's just, and all is going to be one of the things that'll come up, that there'll be people saying, no, you didn't prove it on my beach. I was exceptional for some reason. Or I have opposed to this, since so and so and so and so. So the challenge of opposition is going to be there. It's going to be there. There's no way we can get around the lawsuit.
Unless somebody else has something, I make a motion that we adjourn.
Second.
Thank you. You're adjourned. Thank you. Oh, boy. Okay, now the 27th at 4 o'clock.
I barely glanced at it, yeah. So what do you got in there?